Good morning, everyone. I'm Susan Kohlmann, president of the New York City Bar Association. Thank you all for joining us for this program, Hot Speech on Campus and in the Profession in Times of Turbulence. You're taking the time to be here for this in-person all-day program speaks volumes about this topic's importance. The genesis of this program began with the Israel-Hamas war that started in October and which reverberated throughout the world and understandably became the #1 topic of discussion. And certainly in this country, as people began expressing their opinions, we started to see people, many of them well-meaning, lose their jobs, get canceled, threatened with violence, and even assaulted for expressing their opinion. On a topic so difficult to have a civil conversation about, not only did it seem that everyone had an opinion, but it also seemed that everyone was expected or required to have an opinion. I can tell you that many of our staff and members who have crafted statements for years on issues in the public interest have struggled mightily to find the right words. The City Bar is increasingly diverse in a variety of ways, including that our members hold a diversity of viewpoints on current events. It's a challenge when you know that whatever you say, some people, including reasonable people with whom you have lots in common, not to mention friends and family, will be disappointed or worse. Throw in the limitations of social media and remote modes of communication that seem to work at odds with interpersonal connection, and the difficulties are only compounded. I want to pause for a moment and make clear what we are not here to talk about today. We are not here to debate the merits of the underlying issues. We are not here to talk about the Israel-Hamas war. Rather, we are here to talk about speech, about talking. What is the relationship between free speech and academic freedom? Where does the law come in, whether under First Amendment principles or otherwise? And where should it come in, on campuses and in our workplaces? When, if ever, can reasonable limits be placed on speech in order to align with organizational values and provide inclusive and safe spaces? Is there even such a thing as a safe space? What are the implications for the recent push to bring one's whole self to work? Can people really bring their whole selves to work in this environment today? And at a time when it seems there's no shortage of opinion, but civil discourse is in very short supply, how can university administrations and executive management create environments for the free, civil, and safe exchange of ideas? If anyone can begin to answer these questions, or at least equip us with a framework and set us on a course to do so, it is the remarkable gathering of experts here today, whom I thank profusely for joining us. I want to express my great thanks as well to Judge Marcy Kahn, chair of our task force on the rule of law, and Mary Lou Bielek, sitting back there, co-chair of our council on the profession, and their colleagues for putting this program together. I look forward to a very interesting and productive day. Thanks so much.
Thank you so much, Susan, for starting us off this morning and for your vision and your leadership in launching this program. I know it was very important to you, and we are going to try mightily to adhere to the goals you've set for us. I'm Marcy Kahn. I'm co-chair of today's program, along with Mary Lou Bielek, whom I heartily recommend as the best possible person with whom to plan a program which has innumerable moving parts. And I add to this, our welcome to you to this very special City Bar presidential program. Mary Lou and I extend our thanks to the members of the planning group, as well as the co-sponsoring committees, all of which are listed on the program notice, which you've received at the registration desk and which is available on our website, for their many important contributions to today's presentation. I would also like to thank the law firms of Jenner and Block and Paul Weiss for their generous sponsorship of our luncheon today. By the way, our website, which is accessible via either the link or the QR code on the program that you received at the registration desk, also provides the full bios of all of our wonderful speakers and their accomplishments as thought leaders in this realm. The website also contains a deep bibliography of materials on hot speech, which the planning group has put together with the help of our speakers to spur your further thinking on these issues. Be sure to check it out. These materials, the materials list contains hyperlinks to all the documents, a number of which have been authored by our speakers. In addition, advanced copies of a forthcoming book on academic freedom, The Right to Learn, by two of our presenters, Ellen Schrecker and Jonathan Friedman, are available for purchase in the reception area across the hall where we will be having lunch. The program today is being recorded on video and will be accessible via the website within the next few days. Please let your colleagues and friends know that they can view it there free of charge. To give you an overview of the plan for this morning, our session on hot speech on campus will consist of 3 parts. We will begin with a very special video presentation by one of the nation's foremost authorities on the foundational principles underlying free expression on campuses, after which we will have a short break. We will then launch into a very lively Fred Friendly style panel discussion of law school leaders and others commenting on context-based hypothetical situations from diverse perspectives. After the panel discussion, we will hear from a renowned historian of the McCarthy era who will share lessons learned on labeling, censoring, and policing political speech. Given the enormous emotional impact of this topic, especially as it relates to the Israel-Hamas war, we have some rules of the road we need you to follow. First, in our discussion and presentation, as Susan has said, we will not be debating the issues surrounding that conflict. We are instead desirous of helping the leaders of our institutions develop the best possible approaches to dealing with these fraught and painful situations arising from political expression in our academic and professional settings. Further, we will not be focusing on any particular institutions. Our hypothetical scenario this morning was developed based upon events which have occurred at multiple campuses. So if you think you recognize a particular institution, I am telling you right now, you are incorrect. Finally, we plan to leave some time at the end of the panel presentation for some questions from you. We will be taking written questions only. You may write your questions on the note cards available at the registration table outside the hall. You should have gotten some when you registered and checked in, but if you didn't, don't worry. You can pick them up after the video. We'll have a short break and before the panel starts. Bar staff members will start collecting the questions toward the end of the panelists' presentation. I expect about 11:45, and we will get to as many of them as time permits. We have an extraordinary and diverse group of experts assembled to help us find optimal approaches to addressing the challenges facing our legal institutions and those leading them where controversial speech and action appears too hot to handle. Our introductions of them will be compressed to maximize the time for their presentations. Again, please go to the website to learn more about these distinguished scholars and practitioners. To begin our presentation this morning, you will be treated to a video interview of Robert C. Post, Sterling Professor of Law and former Dean of Yale Law School. Professor Post will be answering questions put to him by Matthew Diller, Dean and Paul Fuller Professor of Law at Fordham Law School. After our mid-morning break, Dean Diller will serve as moderator of our panel on hot speech in our law schools and on our campuses, basing his questions on our hypothetical. We are deeply indebted to Dean Diller for his major contributions to shaping this panel discussion. We are also grateful to the Education and Law Committee at City Bar and its co-chair, Professor Jonathan Glader, for their work in developing the hypothetical. The distinguished group joining Dean Diller on the panel consists of Mark Alexander, the Arthur J. Kania Dean and Professor of Law at the Villanova University Charles Widger School of Law, Dr. Jonathan Friedman, the Cy Sims Managing Director of U.S. Free Expression and Education Programs at Penn America, Lauren Hartz, a partner at Jenner and Block, where she co-chairs both its education practice and its DEI Protection Task Force, and Trevor Morrison, the Eric M. and Laurie B. Roth Professor of Law and Dean Emeritus at New York University School of Law. We will now view the video of Professor Post being interviewed by Dean Diller.
Thank you so much for joining us today and for helping walk us through a very treacherous and yet important subject that I and many in our country and certainly everyone in higher education has really been struggling with this year, but frankly for some time. And can you describe to us the kind of legal framework for how we should think about speech on campus?
I think it's a great question, and it's a very difficult question especially for lawyers, because lawyers were so used to thinking in terms of the First Amendment and individual free speech rights. And also this idea of free speech has become, I would say, politicized. So you see many groups in the country saying free speech, free speech, free speech. And it's worth pausing, especially among lawyers, to think for a second what we mean by free speech, because it could mean everything and nothing. So let's take the meaning of free speech as we use it, say, in constitutional law. Because normally when people say free speech, they mean free speech as is protected by the First Amendment to the Constitution. And what do we mean when we say free speech protected by the Constitution? We're referring to a very large body of doctrine, a very large, not to say swollen body of doctrine, by which we protect speech, say, in the public square. And I'm just going to pick, say, 3 rules of First Amendment speech, which are fundamental, so that if these rules aren't respected, you couldn't have free speech. So rule number 1, let's say, is no compelled speech. Again and again and again, our courts have told us you cannot compel speech except if it's subject to strict scrutiny. And if they compel speech, that's incompatible with freedom of speech as we define it constitutionally. So do we compel speech in universities? And here, let's think about students and let's think about professors. And I'm talking now about universities, not state universities, not private universities, universities, all universities. So do we compel speech? With students, let's call that examinations. Let's call that assigned papers. Of course we compel speech.
I've called on a student or two in my time as well.
Exactly. And what about professors? Well, what we call that is publish or perish, right? If you don't produce, you're not going to get tenure. You're going to be sanctioned in one way or another. So we compel speech routinely. It's part of the process of being at a university. What about, there's an idea that no viewpoint discrimination or content discrimination. Can't do those things in ordinary First Amendment land. What about at a university? Well, if I just was teaching First Amendment this morning, and if a student started talking about March Madness, it wouldn't have been a good thing, right? I assign a professor signs up to teach First Amendment. They can't be teaching about baseball. If I'm hiring a professor, I want to hire them to teach in a certain subject matter. If I'm giving a grant, I pick by content. Universities are full of content discrimination, both for students and professors. Here's another rule that we say is very important. We say that in the First Amendment, every idea is equal to every other. And there are many ways in which the court has said this. It's said it in Mosley, if you remember. They say there's an equality of status in the fields of ideas, said the court, quoting Alexander Michelson. Or in Gertz, the court has said there's no such thing as a false idea for purposes of the First Amendment. So what about students? This is what we call grades. You know, our job is to help students distinguish between good and bad ideas. That's what we do in a university. Again, not state, not private, universities. We educate, and education is about discrimination between better and worse ideas. And what about faculty? Well, you know, if you're in a history department and your young untenured professor says the Holocaust didn't happen, that professor is not going to get tenure because that idea is not a very good idea. We make these judgments all the time. We are machines to make these judgments, which are prohibited under freedom of speech and the First Amendment. Or, you know, I could pick 1,000 examples like this. Here's one more just off the top of my head, a prior restraint. You know, very bad thing in First Amendment land, but we conduct classrooms and a student doesn't speak unless they raise their hand and they get called on. That's called a prior restraint, right? You need approval before you talk. Or we say that you can't have discretion in the governance of speech. And in a classroom, of course, you have complete discretion in how you govern the classroom speech. So what is this telling us? It's telling us whatever freedoms there are, and there have to be important freedoms. I'm not saying no freedom. There are important freedoms in a university. They are just not the kind of freedoms that we mean when we say free speech. And we refer by that to the First Amendment of the Constitution. It's a completely different regime of speech governance, and it makes no sense to apply First Amendment standards to a university because we don't operate that way. So go ahead.
Yeah. So, well, why don't you continue, and then I'll because I think you're getting to what I'm going to ask you about.
So then the question would be, of course, you know, we do need freedoms. What sort of freedom do we have at a university? And what we have is academic freedom. Now, the point about academic freedom is that it's organized around the ability of faculty in the classroom and in their research to fulfill the mission of a university. So what I've just said is universities are very special institutions. They have a function. And typically we say they have two functions. One is research, to create new knowledge, to transmit existing knowledge in an accurate way. And the second is teaching. And by teaching, we mean instilling in our pupils who are of a certain age a mature independence of mind. We teach students how to think for themselves with analytic clarity, how to do the work necessary to become a mature thinking adult. That's the object of higher education. So to do those things, you need a certain sort of freedom. But what kind of freedom do you need? Well, if the object is to advance knowledge, we need the freedom to think critically and advance knowledge. So you can't make new knowledge unless you're free to critique what everyone thought was the case. So you write a new article and you're critiquing the masters in the field. Do you get to do that? Yes. But when I do that, am I subject to the evaluation of those in the field for my competence in doing that? Yes. Because if anybody could say anything that came into their minds, no knowledge would be increased. Knowledge is increased when people who are literate in a discipline speak new thoughts to those who are literate in a discipline. It's not when anyone says whatever is on their mind. That's how research adds to the store of knowledge. Knowledge within the purview of the university is a disciplinary thing. Now, that means that when I speak and when I have my ideas in research and publication, I should not be judged by people who are incompetent to judge my own competence in my discipline. So I shouldn't be judged by the state. I shouldn't be judged by lay people who happen to be administrators. I shouldn't be judged by alumni. I shouldn't be judged by the public. If I'm in a religious institution, I shouldn't be judged by the church. I can only be judged by other faculty who are competent to judge my ability to add or subtract to the world of knowledge creation, to the world of research. So the meaning of academic freedom in the United States, and this is the way it has been since 1915, is that I am free to say anything in the service of publication and research, so long as it doesn't reflect my incompetence to be a member of the faculty, and only faculty are truly competent to make that judgment. That's the essence of academic freedom. Notice that academic freedom on this account is a freedom of the corporate body of the faculty, not of individual faculty members. And that's one thing that separates it from the First Amendment. The First Amendment is an individual right, whereas the right of research is a right of the corporate body of the faculty to self-police faculty. It's a professional self-regulation claim, and make sure that faculty are free to say whatever they need to say in order to advance knowledge. And
can I stop you there?
please.
I want to just take you back a bit before we go down much further on the academic freedom front. I want to take you back for a moment to the First Amendment piece, which in essence you say it's kind of a category error to think of this as First Amendment issues as opposed to academic freedom issues. But let me just press you on that for a moment. So public universities subject to the First Amendment, and then I think your position would be that in turn is subject to the mission of the university. What about residential universities? Students live at the university. They don't only go to classes in the university. Their physical space around them is the university campus. What's the protection to them to express ideas and thoughts that may be contrarian?
So let's come back to public universities and then let's get to particular areas in the university. So a public university is a state institution with a mission. And all state institutions with a mission are empowered under our Constitution to regulate speech as necessary to attain the mission. So think of a court. If you walk into a courtroom, you don't have freedom of speech in any ordinary sense. The judge is the governor of the courtroom and governs it in order to attain justice. And that authority, let's call it managerial authority, which is quite different than the authority that the state exercises outside of an institution, call that the authority of governance. The authority of the court diminishes as you leave the courtroom, but it doesn't evaporate entirely. So a judge can put a restraining order on an attorney when the attorney is speaking about an ongoing trial to the general public. But the standards are different, obviously, than speech within the courtroom. Universities have the same issue. They can regulate speech in the classroom when people speak qua teachers or qua students as necessary for the education. And as you get farther from their being in the role of student or education, that authority weakens. But the general test is the speech, one, within the scope of the managerial authority of the institution? That's a complicated question that we can talk about. But if you're in a university dorm, it obviously is, which is the hypothesis that you gave, or if you're on the campus, it plainly is, right? So you're within the scope of the universities, and the university can justify that regulation as in terms of protecting the educational function of the university. In K-12, this is governed by the Tinker substantial disruption test. A student can speak qua citizen in a public school so long as it doesn't substantially disrupt, and courts have given many different meanings to that. But something like that is going to happen in higher education, and that's a very different test than an ordinary First Amendment test, which, as you know, would be Brandenburg, or a much harsher test, whether the state can regulate somebody speaking in a park. And the fundamental reason why academic freedom and First Amendment rights differ is that First Amendment rights are designed to protect the participation of individuals in the formation of public opinion. And that means that the state can't be permitted to set the agenda of public opinion formation, hence no content discrimination. It can't be permitted to say this person is an expert and hence governs what's considered to be true or not true within public opinion formation, hence all ideas are equal. And it can't be permitted to distort the meaning or what public opinion is, hence it can't compel people to contribute to public opinion. None of those things are going to be true in a state university.
Let me ask a few more questions on this because I think on the face of it, your assertion is a very strong assertion. So am I right in listening to you that there still is First Amendment scrutiny? The First Amendment doesn't drop out of the picture. It's just that the university's restrictions then get filtered through an added layer of inquiry, which is how does it relate to the educational mission? Is that right?
Yeah. They become the kind of inquiry which actually becomes synonymous with academic freedom, because academic freedoms are the freedoms designed to serve the mission of the university. And so as a practical matter, they become very similar.
And I just want to press you on one more point on this. So students live on the campus. They're political animals. They have political views. They vote. They organize and work in elections. So that does strike me as going to the heart of the purpose of the First Amendment. And so isn't there a First Amendment value that goes beyond the fact that it's part of the educational mission of the university, the fact that they are allowed to participate in public debate, and if you live at a university, where else are you going to do it?
Well, that's an easy question. You can do it anywhere you want, except the university. But let's assume that we have students who are in the university who want to speak as citizens, and they want to make their political views known, etc. And as a general matter, now we're talking a state university, not a private university, because the First Amendment obviously doesn't apply to private universities. So if you're a state, except there are states like California, which by statute require private universities to observe First Amendment standards. So we're talking now to those universities where the First Amendment in terms applies. And the way I think a court would actually analyze this, if it were to correctly see the problem, because you can never really predict what courts will do, in fact, is this: the student should be free to speak as citizens, except where it negatively impacts the educational mission. And we can calibrate that balance however you want. In K-12, it's calibrated by substantial disturbance, but substantial is generously interpreted. My guess is it'll be more strictly interpreted in higher education, but still it'll be interpreted something like that. And that's a very different test than ordinary First Amendment rights that you would have.
Okay, I've taken you back to the First Amendment path for a bit, but now let's return to the academic freedom path. And as you've described, the heart of academic freedom goes to scholarship and research and teaching in the classroom, where, as a professor, I mean, I like the idea that the professor gets to control, the content of the discussion in the class and gets to rule some comments out of bounds and can even take that into account in terms of, grading, which, means I can do it punitively if I want. So I'm on board with that. I appreciate it. We could have a discussion about the limits of that, but I think, but let's leave that to one side. How does the academic freedom concept and protections apply outside of the classroom once you move on to campus life?
There are a number of ways to answer that. The first is I'm going to give you now the positive law of academic freedom as it exists in contracts, because mostly academic freedom exists as a contractual right that professors have when they sign up to a university that has agreed to protect academic freedom. And the reference there is to the 1940 AAUP statement, which has been signed by most institutions of higher education. And I'm going to be a little controversial about this, but not much. There are three, and I would say four different kinds of academic freedom that are protected in the 1940 statement, certainly as it's been elaborated. The first is freedom of publication and research. I can publish my research, I can do my research, which we've talked a little bit about. The second is freedom of teaching, which we've talked a little bit about, my freedom in the classroom. And again, this is a complicated subject because if I'm teaching algebra, I have to actually teach algebra. So my freedom in the classroom is governed by competence of a professional to do the task that's been assigned to me. The third kind of freedom, which we haven't talked about, and which is explicit in the 1940 statement, is called freedom of extramural speech. And this is defined as the freedom of a professor to speak to the public about matters outside of his research or her research area. So I'm giving you just a classic case that occurred, a decade and a half ago under Bush 2. I'm a professor of engineering, but I speak to the public about the Iraqi war. There's plainly no relationship between my public speech and my professional research, but that is classically held to be freedom of extramural speech. The university cannot penalize me for speaking out of turn. Cannot, unless it meets the criteria of the limits of academic freedom, which is it reflects on my competence to be a faculty member. And then the fourth form of freedom, which is derived from the 1940 statement, although not explicit, is called freedom of intramural speech. And intramural speech is the capacity of a faculty member to speak within the university community about university things. So I say the president of the university is a jerk, or this is a terrible plan to charge more tuition to the students. And many universities would sanction professors for saying such things. That's protected under academic freedom. Now, I've just mentioned freedom of faculty. And I'm guessing implicit in your question was academic freedom of students.
I was going to get there.
And what's interesting is there is no very strong American understanding of academic freedom of students. We get academic freedom from the German universities where they had Lehrfreiheit and Lernfreiheit, and the latter was freedom of students, because German students had a tradition of constructing universities way back in the Middle Ages, and that carried forward. And it's a little unclear what it refers to, but it was never translated to America. And the only statements I have seen about student academic freedom are really the negative of the statements which define the professional obligations and duties of faculty. So I have a duty not to abuse students. So it is said students have a right not to be abused. Or I have a duty to grade students on academic criteria and not bring in extraneous characteristics. Students have a right to be graded only on in it. So they're mirror images, but there's no, that I know of, definitive or even much widely accepted notion of student academic freedom. So the way in which I think that most universities regard student rights is the following. Our job is to educate students, and educating students means getting them to think for themselves, which is a very complicated task. And those regulations which can't be justified in those terms and which cannot confine unnecessarily the independence of student minds are really inconsistent with the educational mission of the university. That's soft, but I think more or less that's where most universities put the ball.
So one, I would just want to make explicit one point that's implicit, which is once we shift from the First Amendment to terrain of academic freedom, we're talking about norms that govern private universities as well as public universities, and that the two end up therefore largely on the same playing field for these purposes.
I would say not norms, but functional. There's the same functional notion. And the interesting thing about that, just to emphasize it so everyone is clear about it, is there is no theory of education built into the First Amendment by itself. I protect freedom of speech, not to educate anybody, but to allow the full expression of persons when they want to influence what the government is doing. Whereas the way in which we think about freedom of speech in university is always within the context of a theory of either education or research.
So if in state universities, the traditional First Amendment protection is subject to the purposes and goals and management of the university. And then in the private universities as well, it all falls under academic freedom. And there is no particular academic freedom for students to express their political views and engage in regular political discourse, because academic freedom, for students at least, is more focused on the strictly academic side, as you were discussing. Then the free expression norms, it would seem to me to emanate from the mission of the university in terms of giving students the flexibility to explore and engage in dialogue and discourse and express their views. So it's not like those norms don't exist. It's that they stem from a broader part of the university's educational mission.
Yeah, I think that's very wise. And first of all, when we come to students, there is going to be an important difference between state and private universities, because a student at a state university can claim whatever First Amendment rights exist for the student, which is to say, I should be free to express myself as a citizen, except if it interferes with the educational mission. Whereas that claim can't be made at a private university. Now, the educational mission of private universities in the United States, where we are very distinctive in the world because we have a marketplace in higher education. Higher education is chiefly private in the United States, unlike most countries where it's chiefly public. And institutions of higher education compete with different educational missions. So it could be the mission of this institution to make good Christian souls out of its student population. And it could be the mission of that institution to make them little researchers, and it could be the mission of another institution to make them good citizens. Universities compete with each other in how they understand higher education, and all of that, and the mission of higher education, and all of that will have important implications for what kind of freedom of speech they give their students, unless regulated by positive law.
One other question I just wanted to come back to on the distinction between on-campus conduct and off-campus conduct, which you referred to before. How should we think about conduct in cyberspace? Because so much expression goes on now in social media and on the internet. When someone posts something on Twitter or Instagram, is that on-campus speech or off-campus speech?
I think it's very controversial. It's uncertain. The court just decided a case called, it's actually pronounced Manoy, but it looks like Mahoney. It's a Breyer opinion about off-campus speech in a high school. And the court said off-campus speech can be within the scope of a K-12 school's authority, but we're going to tip the balance towards student speech, towards freedom of student speech for a number of reasons. One is if the school governs everything that a student does off campus, it's governing 24/7, and that doesn't seem fair. Another is that, says the court in this case, although it said different things in other cases, the function of a K-12 is to prepare students to be democratic citizens, so the school itself should want that student to be free to say obnoxious things. That's basically the logic. I think the same logic would extend up to higher education with an even heavier thumb in the scales for off-campus speech. So if, for example, just to pick a simple example, you're teaching at a college and somebody is saying things on the internet off campus that is bullying a fellow student and making the life of that student impossible in the university, my own intuition is the school should have managerial authority to be able to sanction that student within the confines of the school, to say you can't treat a fellow student that way. On the other hand, if the student is saying obnoxious political things, it's going to be much harder to claim, and probably shouldn't claim, the managerial authority to regulate that. So it's going to depend on the strength of connection between the particular speech act and what is legitimately within the managerial purview of the school.
I'm going to shift gears, and we haven't talked about this, so I'm not sure you're up on it, but I wanted to ask about the new ABA Standard 208, which is entitled Academic Freedom and Freedom of Expression, and it's now a accreditation requirement that all law schools adopt, publish, and adhere to written policies that protect academic freedom, and that academic freedom is defined as including expression by not just faculty, but by students and staff as well. And just to make sure everyone's familiar with it, I think you probably are familiar with it, a law school shall adopt, publish, and adhere to written policies that encourage and support the free expression of ideas. A law school's free expression policies must protect the rights of faculty, students, and staff to communicate ideas that may be controversial or unpopular, including through robust debate, demonstrations, or protests. And second, prescribe disruptive conduct that it hinders free expression by preventing or substantially interfering with the carrying out of law school functions or approved activities. It goes on from there, but how does this change the landscape of our discussion?
Well, I think it was it wasn't carefully worded. So what is the right of free expression of students is left entirely opaque by that standard. First of all. Second of all, what interferes with the learning process is left opaque. It has a particular scenario in mind. It has the scenario where people demonstrate and prevent someone from talking, and it says you can't do that. But there are many other ways to interfere with learning. I mean, suppose that you have a group that is, say, anti-gay, and they single out and chant whenever a gay student walks by. They're not preventing someone from talking, but they're certainly interfering with the education of the students, and they're doing it through demonstrations. So, are they protected or not? You couldn't tell from that regulation, because it doesn't very carefully understand that what's at stake here is education, and the way in which education has to take priority, or you really don't have a school anymore.
So one of the things that might be considered, that some universities might consider part of their educational mission, is promoting discussion in civil and respectful terms.
Correct.
And therefore they might view discussion that does not fall within those bounds as contrary to their educational missions. I'm pointing this out because there's an interpretation of this new that the ABA provides to this new standard that says concerns about civility and mutual respect, however, do not justify barring discussion of ideas because they're controversial or even offensive or disagreeable.
I think that's first, I think that's a misstep. But second, I think it doesn't understand. It does what's doing the work in that interpretation is the idea that it's an idea, and that people get offended by ideas, and it doesn't distinguish that from incivility. So incivility is a different concept than being offended by an idea. I agree with the thought that the function of a law school should be to get students equipped to deal with ideas they find offensive. But that's quite different than dealing with somebody in an offensive way. And if I can't, and we might even say that you can't have a discussion unless you can deal with another person in civility. Other than that, you have a shouting match, and that doesn't educate anybody in anything. So whoever drafted that wasn't very careful.
And I just, looking at it, I should have read you the sentence that leads into it, which says, becoming an effective advocate or counsel requires learning how to conduct candid and civil discourse in respectful disagreement with others while advancing reasoned and evidence-based arguments. Concerns about civility and mutual respect, however, do not justify barring discussion of ideas because they're controversial or even offensive or disagreeable.
Right, but then a lot of work is being done there by discussion.
Right.
So what is a discussion and what's an uncivil discussion versus a shouting match? How do we draw that distinction? You can only draw that distinction in terms of civility, and yet it seems to rule out civility. So I don't think it's very careful draftsmanship.
Or it could mean that you could regulate civility, but you can't regulate content of ideas.
That would be my preferred interpretation. I do think that it's a bad thing when we as professors who have the job of equipping students to deal with ideas, and in particular to deal with ideas in a democracy where we have to live cheek by jowl with people who we detest and have ideas we detest. Our job is to equip them to deal with the ideas. And so to censor ideas as an idea, I think I would view as antithetical to what a higher education, and particularly a law school education, is about. But that's quite different than teaching people how to deal with respect, how to listen, how to attend to an idea and respond to it in a constructive way. When I use words like constructive, I think that's inseparable from words like civility.
So let me step back and ask you a broader question, which is you've observed all the what's unfolded on campuses, over the past 6 months, the debate about it, how it's been handled in public sphere and media. Any advice for those of us who are leaders in higher education on how to think about or handle these issues going forward?
I think the one thing that leaders in higher education do not need is unsolicited advice. That's the first thing.
I asked, though.
I think you got too much coming your way from it. But the first thing I would say is education is a very complicated process because it means taking people as you find them and leading them to a different place. So you can't take someone who is, let's say, paralyzed by hearing certain ideas and just say, listen, listen, listen. You have to hear them. You have to get them to a place where they can hear them. So education is a very deeply contextual and circumstantial profession where we have to take people as we find them to get them to the place where we want them to be, where they can hear any idea and deal with it. You can't just presume that's the case. That's the end process of education, not the beginning of education. So the first thing is we have to understand education as a process, and we have to understand that when we are engaging in that process, we need a lot of leeway to deal with people as we find them. If people shut down, you're not educating them. We have to get people to want to be educated. It has to be positive in many ways. And when we attempt to regulate that through these rules, and we're going to lay down this rule or that rule, anyone who's doing that hasn't really been an educator. That's what I have to say. That's the first thing, So we as educators need to have the flexibility to do that sort of thing. And the second thing is that we have to keep our eye on what we're trying to do. We're not trying to protect sensibilities. We're trying to educate. And that means getting people to deal with each other and to deal with what's strange and difficult for them to deal with. That's our job. And that's a delicate job. And the idea of rights and rules is really, in many deep ways, incompatible with that. So whoever is interpreting this ABA standard has got to be very careful about how they apply it to education if they want education to be effective, as opposed to counterproductive.
Robert, I want to turn to a few subjects that we haven't covered yet and that have been central to a lot of the controversies going on. One is the interaction of principles of free expression, whether framed as academic freedom or otherwise, with Title VI and protections from discrimination, and also with protections that are often encompassed in university conduct codes, like freedom from harassment and threats that sync up with Title VI when they're specific to identities. How do the principles that we've been discussing interact with those protections?
Well, the interpretation of Title VI as opposed to Title IX, interpretation of Title VI has been very careful to try to emphasize that Title VI is violated only when a hostile educational environment is created, as distinct from disparate treatment, which is just a flat-out discrimination claim. But if you're penalizing someone for what could be regarded as racist speech, it's typically because the racist speech is so pervasive as to create a hostile educational environment. And this is a much more complicated question, I think, in the context of gender, because gender norms are so contested. And what is consent and not consent, very much contested. So it's much more Title IX that is the object of free expression critiques than Title VI. I'm not familiar with many Title VI claims, which are normally just flat out disparate treatment claims. Whereas Title IX, you do see a lot of claims that sound in freedom of expression. And there's an effort to try to make these compatible by stressing the educational environment. Whereas if you imagine the freedom of expression to be an individual right, not subject to the educational environment, you're going to be much more hostile to Title IX. And that's the scene of controversy here, how you imagine that speech is regulated in the first place within the scope of the managerial authority of a college or a university. That's one point. A second point, which is a very important point to me anyway, is that these statutes are enacted to provide access to education on the and make sure that that access is not precluded on the grounds either of sex or of race. And so the function of these statutes, what they were enacted to do, is to provide greater educational opportunity. And the way they have been interpreted in the last several decades has been as criminal penalties. They're interpreted to say you can't, if you cross a line, we're going to punish you. And along with that model of Title VI and Title IX enforcement has come issues of privacy and of non-transparency. We protect the rights of defendants. We don't talk about them. And if the point of these statutes has been to create norms within the larger educational community, which are norms of respect, notice we come back to the theme of civility that we talked about earlier, to create norms of respect, both on grounds of sex and on grounds of race that are inclusive, that allow all to participate and aren't excluded by norms of incivility. The way in which the enforcement of both Title VI and Title IX has developed are precisely antithetical to that, because we would want procedures not which are oriented toward punishment, but nor oriented toward education, educating the community as to what norms are expected of them. And we'd want to turn these proceedings into fora in which the entire community can learn and acquire the norms which we deem necessary for inclusion. And the development has been exactly the opposite of that.
So I will say, I mean, I have seen what you mean in terms of the confidentiality norms around disciplinary proceedings being frustrating on many levels within the community. But let's come back to the issue of kind of pervasive hostility, because we have seen complaints of that nature more recently, linked to political protests, to questions about what constitutes a threat, what constitutes harassment. Have we been getting that wrong as well? I guess many of those have not been adjudicated yet, or we don't know how they've been adjudicated.
You're talking about after October 6th?
Right.
Okay. So, I mean, here we have a very particular kind of problem, because by hypothesis, we have two different groups within the university, and each are claiming incompatible norms of respect with regard to each other. And so the administrators in universities now are being torn in two entirely incompatible directions with regard to these two communities. And so one thing is to throw up your hat and you say, I gotta choose one community or the other. But if you do that, you're giving up important groups within your community. So to me, that is not the way if I were a university administrator, which thank God I no longer am, I would not be tempted to go that way. I would be tempted to find paths of accommodation and of dialogue, and I would be as creative as I possibly could to try to make the political expression of those two groups both possible and understood by the other group in terms of at least the minima of respect that we democratically require of each other. But that, again, would be a process of education. That is not going to be a process of laying down rules that are going to be mechanical, because this is much too subtle and much too difficult a political problem to be susceptible to such simplistic solutions.
I'm stopping because I think we're in a good spot. I completely agree with you on that people expect and hope too much out of these disciplinary processes.
They're not going to go anywhere. I mean, they're not going to do what we want them to do.
Right, they're not going to do what we want them to do.
Yeah.
Thank you for spending this time with us and for really laying out a framework that helps us all think through these issues. I appreciate it.
Thank you, Matt. It was a pleasure to be here.
So now that we have a view of the fundamentals and the framework for this area, complex as it is and somewhat confusing as it is, we're going to move to our morning panel, and I'm going to let Dean Diller take it away.
Thank you, Judge Kahn. Can you hear me out there? And let me just apologize to those of you at the extreme side here for my back, but I think I do need to see our panelists. So you can either relocate or bear with me, and I think you'll be fine, actually, one way or another. You're not going to hear me say thank you so much for the 800th time, so I think I'll just plunge into it, although I do actually want to thank our panelists for being here with us today. And just to give you a brief recap, we have Mark Alexander, who is the current dean at Villanova Law School and the most recent past president of the American Association of Law Schools. We have Lauren Hartz, who co-chairs the higher education practice at Jenner and advises and counsels major universities on many of the issues that we're discussing today. We have John Friedman from Penn America, which has done work and studied campus speech now for almost a decade, probably more than that, and issued a series of reports that I think are attached in the materials for today. And we have Trevor Morrison, the most recent former dean of NYU Law School, and both Mark and Trevor are also constitutional law experts, so that's an added bonus. And let me just say a couple of things at the outset. So one is the topic of campus speech is an extremely broad one, and one that is in the news and at the forefront of our society in many ways. And of course, campuses are a crucible of what's going on in society. They're the place where, you know, the next generation is coming into its own and feeling its voice. And so campuses are traditionally a site of activism and disagreement and often conflict over major ideas. And it's also, the stakes are high because we think about campuses as shaping the future and what our society will look like in the years to come. So passions run high on the subject of campus speech, and we've seen a whole bunch of issues around it. I'll just mention a couple that we won't actually talk about today. So one is a number of states that have banned DEI programming in public universities, including Texas and Florida, two of the largest states in the country. We have Indiana, which just in the past week or two adopted a law that requires faculty at public universities to promote intellectual diversity in their classrooms and in their schools, with a complaint and a punitive system to enforce that requirement. So there's lots of issues going on around campus speech in higher education today. We're going to focus, however, on the war in Gaza and the speech issues that have come out of it and arisen from it. And I'll just say, for my part, and I talk to a lot of other law deans on a regular basis, this has been probably the most challenging 6-month stretch that any of us have experienced or can remember. And we deans, we've been through a lot in recent years, you know, certain health issues in society and pandemics that have been out there. And this one has been particularly trying because viewpoints are so strongly held. They go to the core of people's identities and deeply held belief systems. The issues have an urgency to them, and our communities are divided. And so all of that is a combination that makes this extremely hard to navigate. And so let me tell you one or two more things that we're not going to do today. We seem to have had a long list, starting with, you know, Susan and Judge Kahn's introduction. I've got a few more to add to that. So, you know, as Susan said, we're not going to talk about the war in Israel and Gaza in terms of the substance of it. And then we're also not going to reproduce, we're here to talk about speech, but we're not going to reproduce a debate about speech on campus. That could be done, of course. It would be another program, would be very interesting. But what this program will do is it has a different purpose. The goal is to shed light on the decision processes and the considerations that leaders in higher education take into account
as they navigate all of these issues. And so in that sense, this discussion will be a peek behind the curtain as to how leaders in higher education think about these issues, how they make decisions on them, how they come to terms with them. And as I say, these are some of the most challenging issues that any of us have dealt with. And then I also want to spend a little time focusing on what the current situation teaches us about how we can create dialogue on our campuses in the future, and how we protect ourselves and prepare ourselves for, the continuing conflicts in our society that will manifest themselves on campuses. And then we're going to do this through, as I guess Judge Kahn said at the beginning, through a Fred-friendly-like hypothetical. I find, the idea of the Fred-friendly-like hypothetical, it brings a smile to my face because it reminds me of my youth and Fred-friendly, when that was a thing. So I don't know that term means anything to many people, but it means a lot to me, which is essentially a hypothetical that we interactively walk through with our panelists. And I've got a couple of more caveats and disclaimers about the hypothetical itself. So first, while it's loosely based on incidents and things that have happened around the country, it is, of course, not based on any one university or any one set of occurrences. And that has a corollary to it. And the corollary is that our panelists will not be speaking about their own universities, or in Lauren's case, about the universities that she counsels and advises. And part of that is because the actual decisions are made against the backdrop of much more information, against a particular context of events and histories that are not present in a distilled hypothetical, and they're also made against a specific set of university codes of conduct and policies, and we're not centering on any one set of university codes of conduct or policies. And then also, the other thing that goes with that is we are not commenting or passing judgment on, on the actions of any particular university. That's not our goal or purpose today. So with that, I'm going to begin, and I guess I'll add one more preface, which is just reading through this hypothetical and, one last time in preparation for today. It is painful. It is a really painful series of occurrences. It's painful for me. I'm going to be reading it to you. It's painful for me to read it to you. Nonetheless, all of this stuff is happening in one way or another. We all have different personal connections to it in different ways. So I understand that, and just wanted to call that out, that this stuff is not easy to come to terms with and deal with. And I recognize that, and yet we're going to have a discussion about it. So here we go. I'm gonna plunge in. The horrific attack on Israel on October 7th and the ensuing war in Gaza have evoked strong responses from within the campus community, sparking activism among students and faculty. A number of student organizations have issued statements of support for the residents of Gaza or for the state of Israel. And there have been a number of anti-Semitic incidents, some of them involving student-on-student violence and disruption of a meeting of a Jewish student organization. Some Jewish students report that they're afraid to wear kippahs on campus. So just to start us off, how do we think about these issues? How should a law school, let's put this in a law school setting, how should a law school respond? And I'll turn to you first, Trevor.
Thank you. Thanks for the invitation. I'm glad to be here this morning. So, as I understand it, Matthew's going to walk us through this hypothetical, and we're sort of stopping at certain points and talking about what we have in the hypothetical thus far. So what we have thus far is commentary by different students and groups of students expressing different views with respect to both the attack on October 7th and what's happened since, in particular, the IDF's actions in Gaza. And so that's the sort of speech that we know that's happened on campus thus far. And then there have been actual episodes of physical violence on campus. So students, it sounds like, have been harmed physically and or been threatened with physical harm. And that some are experiencing an ongoing sort of fear of that harm that's causing them to even want to sort of adjust how they present their identity for fear that they may be in physical danger. At that point, if a law school leader, say a dean or a dean of students or something like that, is made aware of these concerns, the physical violence itself is, if it's committed by one student or group of students against others, is certainly a violation of a student code of conduct at any university. And any university that I know of would certainly have a mechanism for investigating that and for determining whether there should be any of a range of possible punishments meted out by the university for the students responsible for that violence. There's also an ongoing responsibility on the part of the university to ensure the physical safety of all members of the university community, not just students, but also everyone employed by the university. And so to the extent that what's being brought to the attention of the leaders of the law school is a sort of ongoing concern about the physical safety of the environment, that's not like a hard call at all. The university for sure has an obligation to investigate, to determine whether there is a credible risk to student safety, and to take measures through campus safety and otherwise. And exactly what those measures would be is going to have to be, I think, very, very context specific. But in contrast to the sort of speech qua speech, the physical danger itself, and especially in a circumstance where it's not just a fear that there might be physical harm, but there's a record of there already having been physical harm, is something that, in my view, no university could justify not responding to, and it's hard for me to believe that any university would attempt to justify not responding to, as opposed to taking very seriously.
Great, thank you. Any other panelists on this issue?
Yeah, I just hold that farther away. Good morning, everyone. Just a quick disclaimer for myself that I am not a law school graduate. I'm not an attorney by training. This is important to understand about the perspective that I bring to the conversation. That said, I am a trained sociologist and a historian. I was trained in an interdisciplinary manner. I went to a certain New York university near Washington Square Park, and I've been at Penn now for almost 6 years working on campus speech issues. My dissertation, once upon a time, was about the complexity of the university as an organization and, what happens therein. And that, I think, informs and animates a lot of the ways that I think about these issues, just from the simple fact that from the outside, NYU is one simple thing, it's a single entity, and on the inside, no single person could possibly tell you everything that is happening on a university campus, etc. So the problem that we're talking about in a lot of these situations has to do with a collapsing of nuance in multiple dimensions, including the idea that it would be clear what happened on a campus in some incident, etc. And even in this scenario, there's all sorts of things that would require, as was said, more information, understanding exactly what happened. The context matters every time. In my role, I have spent many years trying to develop frameworks and ways for people who lead universities to think about these complicated challenges. And the second point I want to make that's I'm just bringing here is that the legal questions are really like the first questions, but they're not the only questions in what we might think of as the way a university responds to any of this. And by university, I could mean a president, I could mean a provost, I could mean a law school dean, I could mean someone in residence halls, etc. And I think there really are three broad sets of considerations. One is the legal and the policy. The second is the kind of what I've called the academic or educational mission of the university. And then the third is, a sense of inclusion or community, an inclusive community, sense of belonging and welcoming. In cases like this one and in many others, sometimes the university cannot do things to punish people for speech or reprimand or conduct investigations. Other times, they ought to. But I think a lot of the conversation gets embroiled in a kind of like, well, what is our legal and what is our policy, and not like, how can we be creative about this? How can we be empathetic as leaders? So many of these challenges actually rest on a kind of sense of insecurity. And this was true 5 years ago with, students talking about trigger warnings on campuses as much as it is true now. And then the other 2 points that I just often make is that people want to understand the rules. We all want to get the sense of like, what are the rules, et cetera. And so what universities haven't done a very good job of, there is no Congress where all presidents or leaders in universities come together and decide the limits of academic freedom. It's actually a very challenging project to bring the law school, engineering school, humanities division, and others all onto the same page about actually where does the university draw the line around speech per se. And absent that, you have the situation we're in now, which is actually nobody really agrees if that tweet crossed the line or not. And then the final thing I'll just say is, in a lot of this, I encourage people, having thought a lot about this, and I'm happy to speak more about it, that ultimately, when you're in the really close calls, it is better to side with speech than against it. And I'm happy to talk more about that as well.
Okay, but let's thank you, and thank you for that broader framework and context. Coming back to my question, is this a speech issue at all? The discussion of the physical violence in this. Mark.
So, as you phrase it right there, discussion of physical violence, that takes it, to me, that's taking us away from speech. And that, I think, partly goes to John's point, like what crosses the line. And that's always the challenge. And so I think that when we are dealing with this, we do have to, as clearly as possible, separate out when there is speech that is just advocating uncomfortable, controversial opinions versus that which tends to lead towards some sort of violent action. And as we start this with that particular, with this hypothetical, when that has actually ensued. And to me, that just also goes to another point of John's, like, we have to think about our mission, and we need to set an environment where our students are actually safe and able to learn. What I think is challenging is, again, drawing these lines, but also students today often use the word safe in a way, frankly, generationally speaking, that I didn't. And and so we have to think about, at this immediate first cut, I think there's an actual physical safety concern. That, to me, is, I have said this a million times as dean, if there's ever a threat to physical safety, talked about it in COVID, talked about it when you had concerns about structural questions in buildings, talked about it in speech context. If anyone's ever actually in danger, physical danger, then there's no question. So I think we start with that, say that has to be. Then we will, I know, get into how speech pushes us towards that kind of danger.
Yeah, so I think I'd like to move on and just to now move into to issues that are more clearly speech focused, but just to be clear at the outset that issues of physical safety and violence are in a different category, really, from the rest of the discussion we'll be having. Although there are ways in which they blend, and this is true whether it's there's a buzzing up here. I don't know if that's possible to turn off the mics up on the podium. It's coming from behind us somewhere. And so let's keep going and get into the heart of it. So at a student, and by the way, the physical violence point pertains whether it's anti-Semitic violence or anti-Palestinian violence, it pertains across the board. At a student rally in support of Palestine, one of the leaders led others in chanting the slogan, "From the river to the sea, Palestine will be free." One student group posted a photo of the rally on social media. The photo includes a banner that says, "From the river to the sea." Several other student organizations and a number of individual students liked the posting. An organization of Jewish students meets with the dean of students and demands that the students at the rally, the student group that posted the photo on social media, and the individuals and groups that liked it be disciplined. How would you think about that? I'll start with you, Mark.
So I think that you start by, part of it is like, who do you bring into the room? And I think that so much of it is, and this is part of the caveat, so much is fact intensive to figure out, who's doing what. But I think the thing is that, to me, in my own experience as dean, half the challenge is getting people in the room and talking to them about what they're doing and what the implications are. And so I think that, getting students in the room and saying, like, well, what are you doing? What is the point of your protest? Or what is the point of your reaction? Where's that coming from? Getting folks to understand, like, here's the nature of the problem. This is, by the way, really hard these days. But getting folks to understand the nature of the issues that they're dealing with, and getting two people who may have different views in a room to say, here's what's happening, and here's how this is my expression of something that's deeply meaningful to me, and someone else saying, this is my expression of something that's deeply hurtful to me, what you have done. So I think, to me, that's a starting point, is getting people in the room. Now, they're not always in the room at the same time, but then also, like, getting your dean of students together. I always love to talk to my lawyer. Our Office of General Counsel is terrific. But trying to get folks in the room to try to get folks to understand the dimensions of the problem. That, to me, is sort of like procedurally speaking, a first step. So that to me is, I guess, sort of, again, without having an answer, because that's, we can't come up with perfect answers to this. Truly, it would be who's sitting in my office with me, who's coming in and out. But I think, and part of that, by the way, also is, as dean, is the intel you gather by talking to your dean of students, talking to the president of the Student Bar Association, talking to the vice dean, talking to another professor who happens to be close with the student in that context. That intel is to me so important, because these are so hard to decide without real, I guess it's like being a judge and getting full facts.
Let me just push you or ask a few further questions on that. So when you say get people together, are you talking about getting people on the opposite sides of this issue together? Or are you sitting down with the student leaders of the protest, or the students who have complained, or all of the above? How are you structuring that?
All of the above, but often it takes one meeting here, one meeting there. The dean of students meets with somebody, then talks to me. And the idea is really to make sure that I'm getting the students, let's say in this context, getting the students to start to be able to see each other's perspectives, and then helping, if I'm going to have to make a decision, helping me get the full facts so I can decide what is going on from various perspectives. So yeah, it's individual meetings. I've had meetings where I sit down and I've got two people who are deadlocked in some situation against each other, so to speak. I often bring food. Honestly, I'm a huge believer in breaking bread, the power of breaking bread. And we sit down and we talk over, the course of an hour, and some coffee and pastries. Not bagels, because you can't get good bagels in Philadelphia. I'm so glad to be in New York.
Trevor, as a former dean, do you think about it in the same way?
I agree with much of what Mark has said, I think. So whether it's the dean, her or himself, or the dean of students, or both, some conversation with the students who are at the center of this seems inevitable and a good idea. At a minimum, that's the students who are raising this complaint. They're demanding that there be some sanction be meted out against the students who are involved in repeating this slogan from the river to the sea on campus, or who are expressing support for it on social media or otherwise. That's sort of the immediate question. Agreeing very much with the general approach that Mark's described, I'll say, if that meeting where those students come to demand this action is like the first significant conversation that the dean of students or the dean has had with those student leaders, you're already in a bad place. So a huge part of what I think successfully managing these kinds of challenges on campus is about is relying on a kind of trust and belief in the good faith of the leadership of the school that's been built up over time by real engagement, that's not coming at the moment of sort of peak heat and light. So hopefully these are students, student leaders already known to the dean of students, that there's a kind of ongoing relationship there. Of course, you're going to have to, I'll just say a little bit on the substance of sort of engaging with the thing that they're demanding. You're going to want to have, of course, as a dean, a good sense of exactly what the university's rules on campus speech are, and whether they are a pure expression of academic freedom ideas or mixing in a kind of, even in a private university, a just more straight up free speech idea. University policies that I'm aware of have a mix of both. And you'll want, very critically, you'll want a sense of the history of how anything roughly analogous involving other subject matter has been treated. Because to the extent that the students demanding that someone be disciplined essentially for the content of their speech here are going to be frustrated if the school does not sanction, their frustration will be maximized if they have a sense not only that what they're demanding is not being done, but they're the victims of some kind of double standard. And so having a sense of the history of how these sorts of issues has been addressed by the university in the past is important. And last one there, it's possible, in fact, I think it's likely that if this hypothetical were to play out and if the answer to the students was physical safety is one thing, and we have and are taking that seriously, but if you're asking for there to be discipline of a student because of the content of this speech and only because of the content, I think most universities would likely say, absent knowing more about the context in which that's been said and whether it's created a dangerous environment and how and when and by whom it's been said, that the speech itself would not give rise to punishment. If that's where the school is going, then very likely the next thing, the kind of fallback that the students are going to demand is, okay, but you know this is offensive and we know it's offensive, so the school has to condemn it. Even if the students can say it without prohibition, we need a statement from the dean.
Let me stop you there, because I just wanted to bring in Lauren. You know, what are the legal frameworks that you would be advising clients to keep in mind as they navigate this? Understanding, of course, university policy is at the top of that list, but there are other legal.
Absolutely. It's good to be with everyone today. And let me just say, I don't know how many of you, like me, have had nightmares of being surrounded by law school deans asking you questions about constitutional law, even after you graduate from law school and pass the bar, but here we are. So, you know, I think the reason why this situation is really difficult as a legal matter is because the university is caught between two overlapping and conflicting bodies of law. And so I want to bring that into the conversation. On the one hand, you have the First Amendment and free speech issues. If you're on a public university campus, then students and other members of the community have rights under the First Amendment that they are going to expect to be protected. And that means that generally when they are talking about matters of public concern, their speech is protected speech unless it falls within a few very narrow and legally defined categories like true threats or incitement of violence or fighting words. And we could debate whether this language would meet those standards, but they're very difficult to satisfy. So that's one hand. On the other hand, institutions that receive federal funding, as virtually all public and private universities do, have obligations under federal anti-discrimination law, including Title VI. Title VI is a civil rights era statute that requires institutions to prohibit discrimination on the basis of race, color, and national origin. And it's been interpreted for about 2 decades by the federal government to apply to anti-Semitism and Islamophobia as forms of sort of shared ancestry or race-like discrimination. And what that means is that if an institution has knowledge or notice of conduct or speech on campus that rises to the level of creating a hostile environment for students that interferes with their ability to live and learn on campus, it has to take action. And so in a situation like this, you have an institution that both needs to protect and respect speech rights, whether constitutional or policy-oriented, for the students involved, but it also has an obligation to students who feel affected by that speech and feel like it's interfering with their own rights to live and learn on campus. And I think that this hypothetical just, I think, really gets to that tension, because while we have, for example, the United States Department of Education, which is responsible for interpreting and enforcing Title VI as against higher education institutions, saying, we recognize First Amendment issues, we interpret Title VI as respecting free speech rights. That's all it's said. It hasn't provided any further guidance to institutions on how to balance those two things. And in its most recent guidance, issued back in November, it relegated the free speech issues to a literal footnote of its letter. Okay, so institutions are really at sea about what it means to balance those two things. And so, as these conversations are happening, whether on the policy or legal level or just on a human level, I think that those administrators need to have an understanding of this complexity and of the institutions, of the expectations that those bodies of law create in all of the different stakeholders to navigate those. So no answers, but additional considerations about why this is so challenging as a legal matter.
Just if I can clarify. Just to clarify one point, is it possible that statements protected under free expression principles, whether it's the First Amendment or university adoptions of similar free expression, or Section 208 of the ABA rules, that statements that are protected may nonetheless be part of a Title VI?
Yes, and I think that's why it's so tricky. So for example, this specific comment we're talking about, from the river to the sea, which is so challenging because it means different things to the people who are speaking it and to the people who are hearing it. The Office for Civil Rights at the Department of Education has cited that specific language as an example of language that can contribute to a hostile environment under Title VI in certain circumstances. So again, I know that the answer context matters was very unpopular with Congress, but in fact, context does matter, and language like this can contribute to a hostile environment. Now, that doesn't mean that the only way an institution can meet its obligations under Title VI is to punish the speaker. In fact, there are many other things an institution can do to meet its obligations. Things like providing supportive resources to the students involved, increasing a safety presence, making an institutional statement condemning what has occurred. There are many things it can do to show that it is aware of, engaged with, and attending to the effective speech other than punishing the speech. But to be clear, the speech can contribute to a hostile environment, and that's why this gets so tricky for institutions.
John, what would you
Hostile environment, okay, is not you feel, I don't know, you feel like a room has turned hostile against you. Can you talk a little just what are the elements of a hostile environment? Because I think you're going to summarize it better than me.
Sure, I'm happy to, and that's a great point. So that is a legal term of art. Folks might be familiar, for example, in the employment context under Title VII and other civil rights statute. But what we typically mean by that, although again, not to keep criticizing a regulator, but there are many different definitions floating out there. The most recent is we're talking about severe or pervasive harassment that substantially interferes with a student's ability to access the resources and benefits of the institution. So severe and pervasive, sometimes we see severe or pervasive, and that is in fact a meaningful distinction. But things like a single use of a racial slur, while extremely offensive, is not going to rise to the level of what we're talking about here. Repeated uses of racial slurs, issues where there's a mix of both expression and conduct, things like that rise to the level. So it is a high standard, and I think we should be clear that well before we reach that legal threshold, students are going to feel subjectively offended and upset. And so I think that goes to your very important point that there's both a legal and policy response to all these hypotheticals, but also a human response. And whatever's happening on the level of law and policy, we also need to be engaging with the students as human beings in terms of how they're affected.
So I'm just going to add on the hostile environment, and thank you so much. is that at the root of this one is also a kind of national conversation about what is anti-Semitism. And we could have that conversation about what is sexism, what is racism, what is discrimination, when is a comment cross a line. With anti-Semitism in particular, the question of political criticism of a state, Israel, versus discrimination against someone who identifies as Jewish, and where is exactly that line. And I don't think, perhaps there is a corollary where there have been some issues raised in recent years by students at American universities from China who feel that things that their professors say or other comments on campus are both, like, in their minds, factually wrong, but also discriminatory against their country to which they feel a sense of national, connection, affiliation, patriotism, the need to defend, et cetera. And so the critical thing in, whether we're taking River to the Sea or any other comment about anything, is really the question of which one is going to dictate the university's policies, the people who are offended by something, or the right of the university to protect people's right to say something that other people might find offensive. And I think the challenge in cases like this that we are facing right now, that was very much on display in Congress and in other cases, is how could you, possibly start to say that even if a group of people find something deeply offensive, that set of words, that statement, et cetera, alone, should be grounds for punishment, because that's so counter to the concept of the university, to words, to language, to literature, democracy, et cetera. And that's really the crux of this too.
So I think when you look at this context,
we'll get it.
Yeah. When you look at this context, can you hear me? Okay, great. I think you can see why, both deans here, their first move was to engage in conversation and to approach this as something. Can you mediate it? Can you reach some understanding between groups that are reacting? In your minds, I would imagine you're thinking about the community and how to hold it together in this particularly tough moment. Having said that, of course, getting people to have meaningful discussions and understand their viewpoints about this issue is particularly challenging and has eluded, most of us, I think, to try and bring around real dialogue on it. Let's focus on the disciplinary path for a moment, and what does that involve, and how does that play? And I would ask either of our deans. Yeah, so the reason I'm raising it is because I think, one reaction people have on offensive statement is that should be subject to discipline. And one could debate that under the principles we've been discussing, but let's say it is, what does that path look like? The dean doesn't just, I take it, call the students into his or her office and say.
Yeah, the dean does not, and actually back to Trevor's point, the groundwork that is laid, when I talk about having folks in my office, that's the last of a whole lot of other conversations. And so I think in the disciplinary context, quite frankly, that's also something where it's subject to the types of conversations to understand what is going on. Because what we want to do is really think about our priorities, and priority, of course, to maintain the safety of our students. We talked about that. We want to make sure we have a learning environment, and not just because it's a legal thing, but a learning environment where there is not severe and pervasive actions that interfere with the students' ability to learn, because we have to protect that, right? We are an educational institution after all. So we're protecting students physically, we're also protecting their learning. So I think in the context, when we're trying to get to and then of course just the fundamental freedom of expression things. Now we are Villanova, we are a private Catholic Augustinian institution, but let's just keep the First Amendment flowing through all this for a minute. You've got those constraints. So I think the thing is, before you get to the discipline, you have to find out like what has been said and where does it fit within those confines. And from my perspective, ideally, I discipline, for lack of a better term. I hand down judgments very infrequently because I'm trying to maintain the community and trying to figure out ways to make sure that we stay together and continue the conversations. And what I do, there's a couple of things, going back to Trevor's point, I, from time to time, go to talks when there's a more controversial speaker, and I lay the ground rules for how we actually just had, quick digression here, Judge Kyle Duncan, who was got rather well known for a visit at Stanford, whatever it was, 6 months ago, came to our campus, and at that time, and I do this from time to time, I said, well, this is how we engage on campus. And I talk about doing it with respect, with dignity, treating each other as brothers and sisters with love and respect and dignity. And I talk about my own life experience. I tell a longer story that's pulled together in the shortest possible way about my sister-in-law's wedding. My wife is white, Irish, and Italian. When I was born, I'm sure my parents didn't think I could marry a white person because it was not legal. The wedding was my sister-in-law who was marrying a woman, and I'm sure that my in-laws, who are the best in-laws you can find in the world, did not think that their daughter was going to marry a black person because, again, it wasn't legal, and they didn't certainly think that their other daughter was going to marry a woman. So the point is, I tell them who I am, and I try to get folks to understand, like, we all come at this with perspectives that matter. I can't say I come at this particular situation as a Jew who is particularly concerned about my family there, or as a Palestinian concerned about my family there. But I try to say, like, understand, we all come with perspectives that are relevant to what we're talking about. So speech doesn't exist in the abstract. So the point of that digression is that the speech, getting folks to understand the speech doesn't exist in the abstract. And we are at law school training people to engage in hard discussions, right? And we're training people to advocate in very challenging situations. We don't pay Jenner rates for easy things, right? You're gonna be out there. So I try to get folks to sort of understand the entire context and then try again to avoid like from on high, here's the discipline. But that takes all the groundwork beforehand.
Right. Trevor.
I agree with all of that. I don't know if this, okay. And just to sort of, I guess, concretize, like, what would this really important point that if we're to take the hypothetical literally, the students have come into the dean's office and just demanded that the dean mete out punishment. At least, at NYU, even assuming a violation of the rules, that's not how it goes. Like, there's a university version of procedural due process, right? There's going to be an investigation conducted, and it's not going to be conducted by the dean or the dean's chief of staff or the dean's office, even. The allegation will have to be, if it's even potentially actionable, not that someone has said something deeply offensive or racist, even, or anti-Semitic, but that they've violated the student code of conduct. And so there's going to have to be a sort of lawyerly look at that and a determination of record. And I think these days, not pointing to any particular university, but I think many formal complaints are being made and investigations are being conducted. One big question here, and again, I'm not making any accusation at all, but Mark mentioned earlier how the sort of the language of safety is deployed quite a lot these days in these conversations, that this set of comments that are deeply offensive to me are implicating my experience of safety on campus. I think those are genuinely felt reactions a lot of the time. And I think there's a risk that some of the time that language is being used in bad faith, that accusations that speech is causing me to feel unsafe are made that way because it's understood that a university that tolerates compromising student safety is a university that's running into legal liability of its own. And so the language of safety is the language that's used to try and motivate a response from the university. Again, I don't think this is the modal case of when someone's invoking safety concerns, but that's a risk there too. And I bring it up here because the very decision to open an investigation can itself potentially chill speech. And so although there's a sense in which the path of least resistance would be, okay, well, you've got a complaint that the code of conduct's been violated, so let's look into it. And I think that probably is what would happen on the hypothetical here to determine whether once all the facts are known, this is a context in which the use of this kind of language is contributing to an environment that would be appropriately called a hostile environment. But we, I think, need to be mindful that even that administrative decision to open an investigation in other kinds of contexts could itself be the thing that would be chilling speech that a university should be concerned about. And again, I think in particular, one would want to know, well, in the past, what has it taken for an investigation actually to be opened? What kinds of complaints have produced at least an investigative response by the university, and what kinds have not? And the reason that matters, final point, is that one of the premises here, often, of if I come to the dean's office and I say, this set of students are saying these things within the law school walls, and that's creating a safety concern for me in addition to being deeply offensive to me. A premise is if the school doesn't do something about it to stop it from happening, then the school by its silence and inaction is endorsing it. And that too is a very dangerous premise for a school to sort of accept wholeheartedly, especially in circumstances where what we would most want is an expression of a variety of viewpoints on really difficult issues. The idea that a university not taking a position on that means that it endorses any one of them, I think, is actually an incoherent position. But it's also very, very risky. But that's why it's going to matter. If in the past a particular dean or a particular school has made institutional statements of disagreement with a particular point of view or set of points of view, and then does not do something in this context, then it could be fair to draw the inference that because they're not objecting publicly, they're endorsing what's been said. And so that's why that question of a double standard, I think, is one of the most important things to be mindful of on the part of the dean.
John?
I think, sorry, I had something really good to say too. I think that we are completely unpracticed and just completely, our students today and many faculty are totally unprepared for how radical the concept of the university actually is meant to be, let alone democracy. I mean, this is a radical proposition, and I've had to think about this a lot. The idea that you're going to take a job and have an office with faculty members who you may vehemently disagree with, or that our students are going to live in dorms or live on campus with people who may have family, where both sides may have family on, alternative sides of a deep international, we'd say conflict, we can say war. That is a radical idea. It's what makes the university so interesting. It is at the core of what the idea of the university in particular, let alone, larger democratic society is supposed to be. But we stopped at some point remembering that that actually takes intervention to facilitate. It takes education. It takes what I've taught a lot about, like how we institutionalize and universalize free speech education when people arrive to campuses. All these people, administrators, students, law students, et cetera, where people are saying, well, what are the rules of the road? What are the rules of engagement? The reason why the students in this hypothetical are asking to punish somebody is because nobody has actually told them how, punishing those people's speech might implicate their own. They don't largely think of things that way. And there is just such an incredible deficit. And then I'll also just say on Israel-Palestine in particular, when I was a college student, I feel like campuses were debating this issue all the time. And I feel like over the last 10 or 15 years, largely campuses felt like they just couldn't even really have controversial debate on difficult issues anymore. And in the wake of that, there's a sort of feeling that this issue, among a few others, is a kind of like untouchable, taboo, undiscussable, unresolvable something, or that one side absolutely will not speak on a stage with someone who holds the other view. And in that context, the university as an institution has just, we're starting to try and get to a place where these students talk to each other, to get to a place where they have a shared understanding of the rules of what they can say and not. We're so far from being able to get these people in conversation from one another. We're so far from bringing them into conversation. And so for me, that is where the universities ought to be investing more right now. And the question of like discipline, even in this circumstance, question of what are the the basis for which we open an investigation, we have to be extremely careful about delineating that and being consistent about it for this issue and others.
Can I just want to echo that and put a fine point on it. The university is in the business of ideas, the business of talking about ideas, ideas which may be unpopular, which may be controversial, which may be difficult, the business of finding new ideas, finding new thoughts, new principles, new theories, and talking about it in the classroom, in the lunchroom, in the faculty halls. And we live in a society that is less and less able every day to do this. We are so divided for so many reasons in so many ways. And that's perhaps one of the reasons why I'm most proud to be, an academic administrator, a professor, because we're losing something, to your point.
And college is the last place we're going to be able to do it.
Yeah, and it's just so important. And I don't mean to glorify our work as universities, but as a society, a great free society depends on the ability of the people to be able to talk, and we're losing that. And that's why what we do, I think, is so important, not because I'm an important person, but because it's important for our society to do these things.
It's not just safety, it's also the word violence that's been connoted in a certain way in all of this.
Let me just return to one more aspect of the disciplinary process, and Trevor, I'll come back to you. So let's say the law school university does do a disciplinary process. Do the students who filed the complaint know the result? What happens with that?
Maybe and maybe not. It depends on let's suppose in one university there is a decision to mete out some punishment. There would be privacy interests that the university, as a matter of policy for sure, and perhaps as a matter of law, would have an obligation to respect for the person who's being disciplined. And so again, this comes back to, I just agree so much with the frame that Mark tried to put this in of trying to have conversations with the students who are calling for a disciplinary process that puts that call in a kind of context and imagines with them alternatives to that. Because what they're really calling for is not a disciplinary process, they're calling for the meting out of discipline that they can observe as it's being meted out. And that last thing is just very unlikely to be realized in a lot of cases, even assuming there is a violation of the university's rules that would trigger appropriate. It's not impossible, it's not unthinkable that there would be, but there isn't a guarantee. And so I can imagine one wanting the dean of students from the very beginning to say, there are alternatives. There's for lack of a better term, counter-programming that could be conducted. There could be, a panel convened on that is educative with respect to the not just offensive but harmful potential impacts of sloganeering, like from the river to the sea, and so that there's a kind of a presumption that there's at least some part of the law school community, the student body, what have you, that is ignorant of the history of the use of that phrase and the potential harm that it brings with it. There's lots of ignorance around that phrase. I think it was the Wall Street Journal that conducted a survey of university-age students, and a dramatically low percentage of them even knew which river and which sea. Let alone what was intended by saying from the one to the other. And I feel like saying that here is, to point to this kind of counter-programming thing, is responsive to the disciplinary question, because again, it's trying to sort of resist the impulse to center the formal disciplinary process as the main event. And I think a big part of the job of university administrators is to see that as a kind of last resort. That doesn't mean, trying to impede someone who wants to raise a complaint from being able to. Universities actually have an obligation not to put barriers in the way of someone being able to raise a formal complaint, but I think it's sort of educating about alternatives that might be ultimately more satisfying.
I want to move on, and I want to bring the faculty into this and focus on some of the responsibilities and considerations that apply with faculty. So let me give you some more facts. A pro-Israel member of the faculty wrote an op-ed in the local paper decrying the student protesters and the words and behavior at the rally, and demanding that the university punish the students for violating the campus code of conduct. So first, is that faculty member's op-ed protected? Lauren, I'll go to you. You're the the lawyer on this. Yeah.
So, I tell my clients, higher ed institutions are the most fascinating clients because they have all the challenges of a private company, all the challenges of a government actor, and absolutely everyone thinks they're in charge. The president, the trustees, the provost, the faculty, the students, the alumni, and on and on and on. I think...
Only the deans know that they're not in charge.
Yeah, you didn't make my list, exactly. No. Let's start with a legal response to that question, which is actually tricky. First of all, if we're talking about the First Amendment, that means we're talking about a public institution and a member of a faculty who's essentially a government employee. If you're at a private institution, you don't have First Amendment rights per se, although you have academic freedom that is likely incorporated into whatever contractual relationship you have with the university. As a matter of First Amendment law, the Supreme Court has actually never directly addressed questions about the First Amendment rights of faculty members. It has addressed questions around the First Amendment rights of public employees. So think, for example, someone who works at City Hall, and it has a whole framework for addressing that. But in those decisions, it has expressly reserved whether a different framework might apply to faculty members because of issues around academic freedom. So typically, in a First Amendment framework you might apply to, for example, an employee at City Hall, you'd ask questions about whether they were speaking on matters related to their responsibilities as a public employee, or whether they were speaking more on matters of public concern as a private citizen. And based on that first cut, different analyses would flow from there. Big picture, what you're trying to balance is any rights that the speaker has to comment on those issues of public concern, about rights that the employer has to make sure, sort of going back to the managerial function we heard about from Dean Post, that the government entity can operate. So, an issue like this I think is particularly tricky because obviously what is happening in Israel and Gaza is a matter of public concern, of deep public concern, and we're seeing lots of commentary there. But here it seems like the faculty members' comments go more directly to university matters in terms of the speech of students, in terms of the university's response to it, and things along those lines. So, I think, again, without providing a specific answer, the Office of General Counsel and the relevant stakeholders would have to think very carefully about what side of that line this falls on. I think regardless of sort of the technical legal answer to this question, though, faculty members expect, I think rightly so, a huge degree of latitude when they're commenting on issues both inside and outside of the university context. And so this, again, is a place where, we've seen people want to immediately push the button of disciplinary process, but I think what would ideally happen here would be a conversation with that faculty member and perhaps the provost or the dean, letting them know of the effect that their speech has had in a non-threatening way, but having a conversation about that, making sure that they realize that may or may not affect, how they comport themselves going forward, but I think it is a valuable dialogue worth having, and probably something that the deans on the stage can speak more to.
Would this be an example of intramural speech that Professor Post was referring to?
So there wasn't a lot of setup in the hypo. It sounds like probably yes, in the sense that the faculty member is commenting on university processes, although it's inflected, I think, with the broader debate about Israel and Gaza. So I think that makes it very tricky. I have spent a lot of the last 6.5 months not only watching grainy videos, because all protests are recorded these days, but also reading op-eds by faculty members and by administrators. And often these lines are very hard to parse. But again, I think that the instinct of framing this as can we discipline is really not the right framework, because ideally where this is headed is not some sort of punitive action for the faculty member, but a dialogue to understand how this is affecting the community.
John, are you okay with all of these administrators calling student groups and faculty members into their offices and giving them talkings to about their expression.
Bingo. It's all about the framing of how such a conversation is set up. Are you being called in a disciplinary way? Are you being invited in? And I think a lot of that does matter into what is communicated. You know, my own go-to for how I've thought about a lot of this is to think about what is free speech on campus anyways, and I have so much I could say in response to the Robert Post video, but I would say, for me, it's about helping people to understand that what we're talking about is open and respectful exchange. Now, on the one hand, we want to invite people in classrooms into being open, and at the same time, we're talking about respectful. So that means, in my view, I think it is okay to say to somebody, the way that you're phrasing that to me, is hitting me a certain way. I might ask you to be more conscientious in the words that you choose and the way that you speak to me. However, I still respect that it is your decision to intake that and decide what words you want to use. And that, to me, that kind of interpersonal sense of that is often lacking in these cases. I think the other thing for me is academic freedom is freedom of research and teaching, extramural speech, but it's also freedom, what's called freedom for internal criticism, which stems from the origins of the AUP and the idea that once faculty are appointed, it was meant to be, and there was some conversation around this around 15, 20, about the idea that faculty ought to be like judges. Once they are appointed by the board or the president, then they should be able to pursue their intellectual work with the same freedom the judiciary holds. And that means also criticizing the university, and there's all these traditions of shared governance that get implicated. I would say that one of the biggest challenges in this moment is, I find it useful to think about this as a kind of target. At the center of the target is expert speech in an expert context. So like, you're a sociologist, you're talking about sociology, and you're in a sociology class. But as you kind of move along two axes, you get to places where we're not sure where academic freedom is, and that is as you move out of your strictly defined area of expertise and out of what we might think of as an expert context. So we know that it is useful for the public when experts speak. Think about public health experts who took to Twitter to help people understand COVID and the vaccine. And the implication that, someone in such a role would be, feel chilled or feel limited in that, could have very serious consequences. And we are already seeing this in many states that have passed laws around critical race theory or other efforts, where what I'm told by many faculty in Iowa and other places is that the majority of Black faculty, in particular, who ever had expertise about race and racism, who used to be willing to go and talk about that publicly, no longer do so.
Let me just pick up on a point you touched on. So let's say the scenario continues, and a number of faculty in their classes on unrelated subjects, so let's keep it to the law school, and so in corporate law, faculty talk about their views on Israeli oppression in Gaza, or it's the other way around, but professors taking class time to salt in comments about their view on the Middle East, on the conflict between Israel and in Gaza. Mark, and students complain to you about it. Is that within their academic freedom?
So, and that's a kind of conversation. I think you're talking about being called into the, I try to do everything possible to avoid a feeling you're being called into the deans to get a punishment. But that's when you have a conversation, and this is often conversation that may also be with the academic dean beforehand. Again, it's not all sitting with the dean, but it's a conversation where you make the professor aware that the students are concerned, and frankly, students, like, their worry is July, am I gonna pass the bar? They are, so they often will say, like, look, they'll say things like, I completely agree, Israel is doing a terrible thing here, I agree, Hamas is whatever, like, I agree with the professor, but I need to learn the rule against perpetuities for the bar. And we need to make them aware of that and make them understand, like, you say what you want to say in an academic institution, but when we put you in a classroom with a certain number of students to talk about the certain subject you are an expert in, then we need them to have that conversation at that time. You know, and it's a different version of time, place, and manner. But the classroom, you know, that's in a property class, you know, that's when you're learning the rule against perpetuities. And if that's the rule for the day, then we make this professors try to understand, like, think about what the students want. Don't think about that we like or don't like your perspective.
Can I just add a bit? Yeah, I completely agree with that, and I think that the Matthews interview with Robert Post gave us some of the kind of, you know, conceptual framework for how to think about what, supposing we do successfully coax into the dean's office the faculty member in question for a conversation, what is it that we're talking about? I would want to, you know, do some work on my own to understand what principles I was going to try and be elucidating for the faculty colleague. And I think it's the contours of what is and is not covered by academic freedom. So there is this understanding that academic freedom entails a right by faculty members to engage in extramural speech, that is, things in which they are not expert, in part because when it's just speech that's going on, there's a kind of concern that if the university is going to itself be adjudicating the boundary of the expertise, that we can be worried there that there will be a kind of overchilling of speech in that margin. But that doesn't apply in all contexts. And we think about academic freedom very differently when we're talking about the teaching function. And that's more like a freedom to decide to make curricular choices within the boundaries of the subject matter that it is your job to teach. And so it's not just that the students want to know, you know, the rule against perpetuities in order to pass the bar, but if this is a property class, the person's job is the teaching of property. If it's a class on, you know, politics in the Middle East, then the person's job is to be teaching that. And it strikes me that this part of the hypothetical, there are parts of the hypothetical that Matthew's given us that are really hard and parts that are less hard, like for me, how to think about the physical safety questions at the beginning. And this is in the less hard side of things. If what's literally happening is that a teacher in a class whose subject matter has nothing to do with Israel or Gaza is trying to make that a forum for their use of their right to extramural speech, they're making a category mistake. And it's important for them to understand that that's not actually an aspect of the academic freedom that comes with their job.
Like it or not, humans are imperfect. And we have set people up for the idea that it is their academic freedom to make those decisions in the classroom. You know, it's January 7th, 2021, and you have a chemistry class, and your students come in frazzled, and you spend 45 minutes of the class asking how people are, and then a Trump supporter wants to get you fired for not covering chemistry. Not September 12th, you know? I think the reality is that we all, I think, recognize, well, you have to see the students who come into the room. Maybe students are particularly animated about the local school board election last night, and you know, most good professors understand that you need some sort of humor or reference to sports or music or pop culture or the world events that we engage students in. Sometimes a lot of professors do this as a way to start a class, to get people into a subject. Now, not everyone does this well, and the art of teaching is also not taught, which is a problem. But anyways, my point is that when we're talking about like discipline and all these things, we have to be so careful to think about what is going to be our consistent rule. You know, this professor sent 10 minutes. Who's going to decide when it was their expertise or not, and whether it was on subject or not? It's complicated for a lot of subjects.
And I think this is also an issue where that consistency point that you made earlier, Trevor, comes into play, because has the school consistently enforced a principle that you can't talk about, professors shouldn't talk about public affairs that are not on point with the class?
Yeah, look, again, if the faculty member has accepted the non-mandatory invitation to come have a conversation with the dean, then having thought through the contours of academic freedom, I think the conversation would be something like, can you walk me through, you faculty member, how you've thought about the pedagogical value of your bringing up that set of topics in a class whose curriculum is not otherwise ostensibly about it? Is it about building rapport with your students? Is it about, the day after a disaster and trying to make space for that, for the emotional and psychological well-being of your students, because that has a connection to the quality of the learning in the classroom? That's one kind of thing. And so I agree with you that the lines here are not bright. But what does strike me as relatively straightforward is the notion that there would be a kind of absolute extramural speech right that could be exercised by a faculty member in the classroom that would underwrite their ability to say anything they want about any topic of public concern. That strikes me as a category mistake.
Too broad.
Okay, I've got one more factual scenario I want to squeeze in. So let's keep going. A truck with a mobile billboard on its side, funded by a pro-Israel advocacy group, begins to circle the campus, displaying enormous photos of students who attended the rally and identifying them by name and branding them as leading anti-Semites on campus. Members of the student group that organized the rally tell the dean that the students feel unsafe on campus, that the truck and the media attention that it has brought makes them targets of potential harassment and physical harm. How should the school respond to that? I'll start. So first, what's the legal framework here, Lauren?
Right, I get the fun job.
Yeah.
So what we're talking about is doxing, and let me give that some definition and legal context so we can have a conversation on the same terms. So doxing typically refers to the publication of private information about an individual with malicious intent. It is a relatively new phenomenon, at least as regards social media. About a dozen states have civil or criminal prohibitions recently enacted on doxing, and only a handful of universities at this time have policies specific to doxing, although, as you can imagine, many institutions this year are considering whether they need to change their policies to specifically address the issue. When it comes to prohibitions on doxing, whether they're in state laws or in university policies, there are two fundamental components of these provisions. There is a substantive prohibition that explains what it prohibits. So this is the publication for private consumption of private information. That might be limited to things like a person's contact information, their phone number, their home address, their email address, or it might be broader. It might include their name or their image. And then there is an intent requirement that typically says this needs to be done with the intent to cause someone harm or to cause a third party to harm the individual. So that is the basic legal framework. Universities are hearing from members of their community virtually every day about doxing taking place online, whether it's doxing of students, whether it's doxing of faculty members or staff members. And it's a really difficult situation for universities for a number of reasons. Not only is the legal framework sort of up in the air, and there is yet to be a square First Amendment challenge to any of these new doxing laws, but also what can a university do in many situations? Sometimes the doxing is by a member of the community. More often than not, it isn't. It's out there on the internet. They have no ability to take it down, so what are their options? I think what we're seeing as a practical matter is, in many situations, institution is offering supportive resources to students or other community members and even their families who are being affected by this. The institution usually can't legally represent the student, although they often need legal representation because of the severity of these issues, and so are sometimes connecting them with counsel outside of the university. And then, where they have what I'll loosely call jurisdiction over the doxer, they're considering whether to pursue discipline or other measures. But there are really tricky situations I've seen. So a common example is you're a student. You have an altercation on campus with someone you don't know and you record it. You send it out to a student group or a group of friends and say, hey, this really upsetting thing happened to me. Does anyone know who this was? And you share the image or you share the video. Someone in that group then puts it on one of the many, many online sites that are devoted to doxing, and somewhere along the way, someone finds the person's identity and shares it, and it becomes doxing. Well, is the first student in that situation responsible for the doxing? I don't know. And so those are the kind of situations that we're seeing, and I think others can weigh in on sort of how they're handling it. But it is a cutting edge issue, and I think in the next year or two, we're going to see a number of higher ed institutions have policies they will promulgate specific to this issue. And it's going to be really hard to think about how they square with free speech issues, how they square with disciplinary issues, and really on a practical level, what an institution can even do about it.
Please.
It's super hard, I think. Maybe we might draw just some distinctions here. So there are circumstances when an individual student, faculty member, or other member of the university community themselves speaks publicly in some way, and then others react in the same space or an adjacent space to what that person has said. But they're not doing that in a way that they're sort of like exposing otherwise private information. They're reacting to what the person has said or done. I think, although there will be hard borderline cases, I suppose, that seems important to keep distinct from what our core concern about doxing would be. Kind of responding with speech or otherwise, other permissible responses to someone's speech is the idea from the free speech standpoint of how this should go. And so it would be, I think, a kind of a distortion of the legitimate concern with the harm that can be caused by doxing to say that we should have a rule that would prohibit that, kind of like responding with speech or permissible action to someone's speech. But kind of outing them and otherwise by way of private information with the intent of causing cognizable harm is a different thing altogether. I'll be surprised if the most aggressive of the anti-doxing laws that I've heard of end up withstanding First Amendment challenge, but we're in a period of real uncertainty, and universities are going to have to fashion policies well before they know the ultimate constitutional answer to the laws that are occupying some of this regulatory space. And just exceedingly difficult. It would be one thing if all we were trying to do was to discourage one group of students from doxing another group of students. This problem is infinitely more complicated because the doxing party is typically not part of the university community at all. And there may be something a student does gets information out into the world there, but you can't bring that third party into the dean's office or the dean of students' office to have any kind of conversation, and that's a challenge.
John?
The big problem really is that social media has also just changed everything, and we all know this, but how long it takes us to figure that out and adapt everything to that. To go to Robert Post's example of the mechanical engineer who, denies the Holocaust on the weekend, that even something like that, if we put it in our contemporary moment, how much more complicated it is if that faculty member is making those posts on Twitter or Facebook publicly and encourages his students to follow him and is doing it like clearly in the hours of Monday to Friday, 9 to 5, but then when do professors work and when they don't? And was he on campus when he tweeted it, or does it matter where he was if it's on Twitter, et cetera? So all those boundaries that once existed, we do not have really good frameworks. And with regard to doxing, I have spent years counseling and speaking to many professors who've gone through some pretty severe stuff. And the experience of getting 300 emails or more of racist, misogynist death threats from anonymous sources, the problem is even when you can identify the one person who sent the one email, if it's 300 emails from 300 people, did any one person give you, severe, excessive, whatever communication? It's much harder to do. So even though the kind of impact of it is so significant, I do think in these cases, everything that Lauren said about jurisdiction, about the universities and what they can and cannot do, but I would just emphasize care and support for the students and consistency in terms of like, what is the threshold? If you're talking about a situation where a university is going to start to connect students with counsel and things like that, like, well, how far does that go? Would they do that for faculty? And, I've been asked to contemplate and give advice on a range of politically complicated issues, like a professor who was critical of the Indian government and had Indian nationalists in the United States making threats to them and wanted to know what the university ought to do for them. And so you'd want to be able to say you were being consistent, right, for any professor or any faculty. And then so that's just, again, it comes back to that principles, policies, consistency, history that Trevor's been talking about. And then the other thing is, with regard to that op-ed that we were talking about before and some of these dynamics, I think it's also really different if we're talking about an op-ed by a faculty member that is highly critical of a whole bunch of students, versus a faculty member who's writing an op-ed on like an issue, even if it's in or not their expertise. Once you're getting into this dynamic of like faculty really critical of students, to me, I don't know that it means it ought to have a different punishment or anything like that around it, or maybe there's a stronger base for a conversation with the professor, but I think that we can recognize that there is a way in which that sort of old in loco parentis and care for students may come to be a consideration in a different way that's unique.
I want to get into some of the questions that have come through, and we have a lot of questions, and some of them have pretty substantial prefaces to them. But one of them is, Trevor, you alluded to this a couple of times, and a theme has been that disciplinary action is not the first thing you go to. There's informal conversations, there's counter speech, and as part of the counter speech is issuing of statements. And so, if the university is trying to balance, offensive speech that is at risk of creating a hostile environment with counter statements, does that set up a whole set of expectations about when the university issues statements and not? And obviously this question about university statements is much discussed. So if you've got some thoughts on that, that's the question.
Sure. So I'm not now dean, so I did not confront the question whether to make a statement in the aftermath of October 7th. And if so, what the statement ought to contain. But this is a perennial challenge, and certainly over the last decade, there have been many moments when deans have had to think about this. And and we've had conversations among deans at the ALS and elsewhere about how to think about this very issue. I don't think there's just one answer. My own sort of philosophy in this has been to think that the more frequently the dean speaks as dean on behalf of the institution, the more we should be worried that members of the community won't feel as free as they might otherwise feel themselves to speak publicly on that same issue. Because no matter what the dean says is going to be taken by some as a kind of statement of institutional position and orthodoxy on an issue. And the first job of the dean is to cultivate and defend the kind of educational environment that the school strives to have. And that tends to be one where all participants in that community feel maximally free. And so I had a kind of stance of, I felt like my stance was virtually never speaking publicly. And I realized by the end of my time as dean that I could count up, and it was like, it was more than a half dozen times that I had made a statement, despite that being my stance. And someone, I remember, said, well, so that looks like, your policy wasn't virtually never speaking. And I said, but you don't know about the 250 times someone asked me to say something and I didn't. And this too is a problem, that from the outside, when you decide not to speak, the world won't know about all of those other times that you haven't spoken. And so each time you speak on behalf of the institution, I think it's not just, you should be thinking about that moment, but you should be thinking about the sort of precedential effect, given that the precedent only goes in one direction. And so for me, if I were a part of a law school leadership or university leadership in the aftermath of October the 7th, the decision whether to speak would be based in very large part on the history at that school of taking institutional positions or speaking publicly on issues of that sort. And if this was a school that did have a history, which I don't say is illegitimate, it's a substantive decision to kind of speak publicly on matters of public concern with some regularity, then it would be much more difficult to justify remaining, and I would think probably not justifiable, to remain silent as an institution in the aftermath of October 7th. It would also probably be very hard to justify only making one statement in the immediate aftermath of October 7th and thinking about, well, what in the ensuing 5 or 6 months gave rise to follow on, and that's the sort of can of worms that one is afraid of opening. So I guess that's a kind of thought process more than a pat answer, but the context in which I think it is most likely to arise is kind of, in this hypothetical, is precisely when the dean or the dean of students says to a group of legitimately aggrieved students or faculty members that the discipline you want to see be meted out is not going to be meted out. And so then they say, well, but surely then this can just, if the best response to noxious speech is more speech, then be part of the solution, dean, and speak. And it's a very difficult thing to say no to categorically, but it's dangerous to say yes to too readily.
Let me just squeeze in a few more questions that we've gotten. So here's one that goes back to the hypo and the student protests and focuses on the social media aspects. How does the social media activity intertwine with Title VI and the hostile campus environment? And Lauren, I guess I'll give that one to you.
So you're looking at me. Yeah. So we don't have a lot of clarity on that in either guidance or decisions from courts. That said, I think a rule of thumb many institutions use is if things happening on social media are having a significant impact on campus, then they are, within the institution's jurisdiction in terms of things that implicate its policies, its authority, its response. And so, I think we are starting to see and will see more of institutions trying to regulate social media activity by student groups and by students. There's actually not a lot of that right now. But I think if you're the institution and you put yourself in institution's shoes, your concern is less, did it happen on social media or did it happen in a classroom, but how is it affecting our community and what can we do about it? So I think that's the right framework.
And I have to say, from my own experience, everything can seem quiet on the surface in terms of, people are not demonstrating in the hallways and everything seems on one level okay, and on the other level, they're all at war with each other on social media, and that's where students are paying attention, and that's where all the action is in today's world. So I think, and drawing the line between off-campus and on-campus is particularly hard, I think, in that context. Here's a question that I think is probably directed at you, John. If the measure of whether, and it's about the gap between the intent of the speaker in terms of, in First Amendment land, is the intent to harm, and what's the speaker's understanding of it, and in Title VI, it's its impact on others, not the intent of the speaker. How do we, and obviously this can occur in lots of contexts, how do we come to terms with that?
So the way that I've thought about this is really that the kind of impact is something that ought to be factored in and be heard and shared, but that when we are thinking about consequences, discipline, punishment, etc., in particular, that we really intent, ought to matter and does play a role, matters. Context always matters in the evaluation of speech, and in particular, the sort of claims that speech, makes people feel unsafe or is violent or whatever it is. I'm not saying we should be so dismissive. I think a few years ago there was this idea of the snowflakes, and we should, they just need to grow up, etc. And now there's this, shifting opinion that no, we have to make the campuses safe for everyone. And to me, the idea that the campus would be somewhere where people never encounter moments of discomfort, it doesn't make sense. But I'll be honest, we're talking about something that is really hard for all of us. Whether, everyone has a word, a phrase, a moment, something that hits you in a particularly harsh way. And really truly a campus where, like a free speech campus where all people can speak and all people can be heard. It's kind of a crazy place. How would you ever do anything, And so, I think in that context, we just need to do more to prepare people for that. But, to come to something I said at the beginning around siding with speech, You know, I've spent also the past 3 years thinking a lot about book bans in public libraries and all sorts of issues related to not just the rights of us to speak, but the rights of people to learn and to receive information and the like. And really, you know, I think in almost all circumstances, the answer cannot possibly be on the side against speech. And so that when these cases are really hard, especially when it comes to discipline or consequences, we have to weigh the consequences of starting down the road of punishing people for things that they say, things that they share. And already, you know, to come back to the other point just about the institutional neutrality, I think it's a real trap. I think universities ought to be thinking again, just in any of these situations, what are their policies? What are their guidelines? What is their consistency? You're taking up a new leadership role. Okay, day one, sit down with a group of people. What is going to be the basis on which you decide to use your voice? But I don't think the answer that you should try to like restrain yourself on all topics or achieve some nebulous notion of neutrality is terribly helpful, because inevitably it's going to be impossible. You're going to say you're neutral, you're neutral, you're neutral, and then something's going to happen and you're going to feel like, oh, I really need to say something on this. And it's going to open stuff. So you're much better off anticipating it. And plus, universities aren't meant to be like neutral anodyne things, like something I'm thinking of like historically HBCUs. Of course we expect them to speak out on civil rights issues, right? They're supposed to have a voice. And so like university leaders or deans, you didn't get that job by being nobody. You're supposed to be inspirational. And people look to you as a community leader. And if a lot of people in your community are upset by something, are you going to tell them, you know, you're neutral? You know, three Palestinian students were shot in the Northeast at 3 different universities, and each of those universities' presidents came out and talked about, you know, empathy for the students and the condemning the climate of anti-Palestinian hate. Do we expect those university presidents to say, I'm very neutral on this? And so it's more problematic. I don't think it actually solves this. I don't think silence solves this.
I think our time is up. I'll add one more dimension to this for us law deans, which is law deans occupy a certain position in the legal profession as well, and the legal profession plays a particular role in our democracy. And does that impose obligations on us and responsibilities to protect our democratic institutions? So that's a program for another day, I think. But there are many, many interesting, thoughtful questions. So I guess that means this was indeed a provocative panel. And I just want to thank all of our guests for participating, and thank you for doing this. This was a fascinating discussion. Thank you.
Yeah, and I want to also add my thanks to our outstanding panel, Mark Alexander, Lauren Hartz, John Friedman, and Trevor Morrison, and our fabulous moderator, Matthew Diller, for really opening our eyes and illuminating the discussion. So I'm going to let them step down, and I'm going to tell you it's now my pleasure to introduce our next speaker. That's going to be Professor Emerita of American History at Yeshiva University, Dr. Ellen Schrecker. She's going to give us some lessons from the McCarthy era. Now, I'm very sorry to tell you that I'm disappointed, but her forthcoming book is not going to be here, but it's called The Right to Learn. You can look for it online and get it yourself, and I'm sure you will find her remarks extremely interesting. So without that, going any further, I will introduce Dr. Schrecker.
So far this has been absolutely fascinating. Now I'll give you a little respite because we're thinking about the past, and of course that's not at all relevant. But I am going to try and refrain from pointing out in my talk what I think is a relevant issue today, because I figure you guys have it all in your heads at the moment anyhow. And unfortunately, we messed up with the book deliveries, but there may be a few books out there, and maybe I can personally sell them to you. There are some cards out on a table in the other room, and pick them up. They're QR codes and stuff. And I am somebody of a certain age and have no idea how to use QR things, but you guys may. Anyhow, before I get into a discussion about McCarthyism in the universities, which is the topic of my talk, I think, I do want to clear away some myths. The first one is that McCarthyism has been misnamed. Joe McCarthy, aberrant and nutty as he was, came rather late to the movement that he gave his name to. Even so, it's a convenient name. Unfortunately, it's a convenient name, so that I tend to use it, and I think most people do as well, to refer to that anti-communist political repression that began in the late 40s and lasted through till the 60s. If there was anybody who I think deserves the name, it would have been J. Edgar Hoover, the FBI director. Not only had he and his men hyped the supposed menace of American communism, but they also operated much of the machinery that was used to combat it. Another myth that I'd like to dispel was that McCarthyism targeted all dissent. That may, in fact, in many areas have been correct, but it was really specifically directed against the American communist movement, and it was designed to eradicate the influence of all the individuals, groups, and ideas associated with communism in the United States. And so, actually, almost all the victims of McCarthyism had some kind of past or present connection to communism. There were few, quote unquote, innocent liberals. The people who were affected most were what I would call innocent communists, most of them former communists, in fact, who had espoused unpopular ideas, but posed no real threat to national security. Yet, they were targeted during what until now I have thought, was the longest lasting and most widespread episode of political repression in the history of the United States. And this was largely because that anti-communist crusade focused on the menace of American communism, actually addressed some of the most disturbing issues of the early Cold War, as well as, and here there will be sort of overtones of what's going on today, especially because the Republican Party brought that issue into the center of American domestic politics. Now, the United States had emerged from World War II as the most powerful country in the world. And yet, by the late 1940s, it seemed as if somehow we were losing the Cold War. The Soviet Union had gained control over Central and Eastern Europe. The communists won the Chinese Revolution, and Russia developed a nuclear weapon several years before experts had assumed it was happening. Now, how could that have happened? Well, the Republican Party had an answer. They had lost the 1948 election when everybody had predicted that Dewey was going to be elected. But it had run on a platform of trying to roll back the New Deal. And for some funny reason, the voting public seemed to like things like Social Security and the minimum wage. So clearly, the party had to find a new issue that could return it to power. And it found that issue in the charge that the New Deal administration had been soft on communism, that it had allowed communist subversives to enter the government and undermine the United States' ability to stand up to the Soviet threat. It was an outrageous scenario, but it had plausibility. There had been communists in government, and there had been spies within the atomic bomb project. And it was a very juicy set of charges that immediately attracted media attention and was quickly picked up by the Republican Party's leaders and by such ambitious politicians as Richard Nixon, whose career took off once he took up that issue. By the end of the 1940s, therefore, even before Joseph McCarthy entered the scene, a full-fledged witch hunt was enforced. Now, McCarthyism operated within a two-stage procedure. The first stage was the identification of these supposed communists. The second was the administration of sanctions against them. That first stage was usually handled, that identification of the supposed communists was usually handled by some kind of official body, a congressional investigating committee or the FBI, for example. And there was also an anti-communist network of sort of professional anti-communists who were giving information and names to the official bodies who were investigating. And they really resonated with me when I realized that there are such groups out there today, but I'm not naming names. Unlike in more, then we get to the imposition of sanctions. And unlike in more authoritarian countries, the political repression of the McCarthyism era was carried out with little violence. Only 2 people were executed, Julius and Ethel Rosenberg, and several hundred were prosecuted and imprisoned for a variety of legal reasons. The main sanctions were economic. People in the beginning with the federal government and extending to Hollywood and beyond, people were fired and blacklisted simply because they had some connection to communism. One authority at the time estimated that it was somewhere between 12 and 15,000 people who were involved in that process. And the academic community participated along with all the other mainstream organizations in American life. Most of these people, from the late 1940s, universities began to ban communist-affiliated student groups. They banned communist-affiliated speakers. They imposed anti-communist loyalty oaths, most notoriously the 1949 California Loyalty Oath that discombobulated faculty members at the University of California. We also know, or at least I've discovered, more than 100 people who were fired and blacklisted during this period. Most of them were, as I had mentioned, earlier, former members of the Communist Party who refused to answer in investigating committees so-called $64 question. You know what it was. Are you now or have you ever been a member of the Communist Party? Now, these people would probably been more than willing to talk about that and said, yeah, I joined up when I was a student at the University of Wisconsin in 1938. I was really involved in the Spanish Civil War, and go on and on. But after the war, I realized this was no longer a viable mode of dissent, and I was trying to raise a family anyhow and didn't have time for 10 meetings a week. But the problem, of course, was that they didn't want to become informers. They didn't want to give these anti-communist investigators the names of the people who had been associated with them politically at an earlier time. But, as I'm sure you all know, the Supreme Court did not protect the First Amendment in this situation, and the only way these people could avoid naming names was to take the Fifth Amendment as the only way to avoid possible prosecution for contempt of Congress, I should say. It was to take the Fifth Amendment's privilege against self-incrimination. Now that looked bad, as if they were hiding something, which of course they were. And to my knowledge, every school that had someone on their faculty who had been targeted during that first identification stage of McCarthyism was investigated, often in secret, but they did get called before their deans usually, even if they weren't necessarily fired. But what's really significant, and what's a huge difference from today, was that they were never asked about their teaching and research, not in their committee hearings before HUAC or Senator McCarthy, nor at the later investigations in their colleges and universities. Some were fired arbitrarily, just like that. Others had that full faculty hearings with all of the procedural guarantees that the AAUP's definition of academic freedom required, but they were let go nonetheless. And it's important to realize that tenure was no protection. Now, we don't have precise figures here about how many of these people were actually fired and blacklisted, because both the institutions that punished them, as well as the tainted professors, kept it secret, the universities, because it would have attracted unfavorable publicity, the professors, because they hoped that secrecy would keep them off the blacklist. But it didn't work. The blacklist was almost universally effective. Its victims either left the academic community or else went to the historically black colleges and universities that were looking for credentialed faculty members at that time, or some of them emigrated mainly to places like Canada and Great Britain. And by the middle to late 60s, many of these people were able to return to the universities, but they had lost the momentum of their earlier careers, and in many cases never recovered the losses of a decade and a half of unemployment, a lack of employment within the academy. Now, all of this, it's very important to realize, universities did not behave any differently than any other institution within American society, with one exception. They supposedly protected academic freedom. As a result, They had to justify what they were doing within the parameters of their own educational mission. This is very important, of course. And they did. By the late 1940s, trustees, administrators, and faculty members who had participated in the dismissals of the professors who had been targeted during that first identification stage of McCarthyism were operating under the assumption that communism in and of itself disqualified somebody from the faculty. They based that assumption on the then widely accepted, though highly exaggerated and demonized portrayal of American Communist Party members as robots completely under the control of their Kremlin masters, who were therefore believed to be unable to exercise the intellectual freedom that is required of a professional academic. Such was not the case. In almost every case, most of the people who were being dismissed had already exercised that intellectual freedom by leaving the Communist Party. And in any event, none of them were ever accused of slanting their research or indoctrinating their students. Not that it mattered anyhow, because once the universities, since the universities were simply focused on trying to ferret out that individual's connection to the communist movement, as well as that person's willingness to cooperate with the witch hunt. Professors who took the fifth, therefore, were treated by the academic establishment as failing their professional obligation to come clean about their past political activities. And I think we could call that a violation of academic freedom. Certainly, within several decades, many of the institutions that had fired these people recognized that they had done wrong and tried to apologize, but a lot of damage had been done. And when we assess the impact of McCarthyism on the rest of the United States, what we have to realize is that the main damage was that it actually narrowed the political spectrum within the United States and made certain issues almost as toxic as Palestine and Israel. When we look at what happened within higher education, what we're seeing is all of that with, that political constriction, but also what the Supreme Court Justice William O. Douglas called a black silence of fear. Students abstain from left-wing political activities, and faculty members censored themselves. They dropped marks from their syllabi. I was told by one man that he stopped teaching a course on the French Revolution. Another man, a very well-known literary critic, told me that during this period, he never used the word capitalism in his lectures. He always talked about industrialization. And another fairly well-known psychologist who later did path-breaking research on human intelligence told me that during this period, not only did he leave the United States for Canada, but he studied rats. That, some remnants of McCarthyism actually hung on within the academy until the mid-60s. But by the late 50s, it was clearly beginning to recede. The Supreme Court was beginning to backtrack and grant more rights in cases that involved communism in one way or another. And politics began to return to the campus communities, largely because of the civil rights movement. American politics had to deal with real world issues like racial discrimination and then later the Vietnam War. So that this hyperinflated menace of domestic communism simply disappeared from American political discourse. By the mid-60s, we all know the campuses were centers of a great deal of activism, but there was also a strong reaction against that. And what we have seen since then is the fact that right-wing politicians and operatives took advantage of that public antipathy to what was clearly unprecedented campus unrest. And I want to point out that I wrote a book about the 60s, and one of my main conclusions was that administrators were totally unprepared for what happened on their campuses, which is exactly what our previous panelists have noted as well. So this isn't new, that people are flying by the seats of their pants. Anyhow, they were under enormous pressure from the right to crack down on students, and they did so as well by criticizing, quote unquote, weak-kneed administrators and faculty members for facilitating the turmoil. Again, something we're seeing today. And we've seen how useful these kinds of charges have been for ambitious politicians. Need I only cite the case of a certain Ronald Reagan, who won office first for governor of California by running against the free speech movement at Berkeley and promising to calm campuses, quote, at the point of a bayonet if necessary. Anyhow, for the next 50 years, right-wing politicians, this hostile portrayal of the academic community has been the centerpiece of a very well-funded, ultra-conservative campaign to push American politics to the right, that had been launched by a self-conscious network of reactionary billionaires and other pundits and politicians. And I think you know what I'm talking about. Those efforts have, over the years, damaged the credibility of American higher education, as well as undermining the nation's willingness to support its public colleges and universities. So today, when red state politicians like Ron DeSantis are demonizing, quote unquote, woke students and faculty members, and ambitious congressional Republicans like Elise Stefanik are grilling elite university presidents about their supposed tolerance for anti-Semitism, which is defined not particularly realistically, as was communism during the McCarthy years. It's all too easy to think we're seeing a return of that anti-communist witch hunt. But what's happening today is much worse than McCarthyism, much worse. To begin with, and there's a sort of ironical moment here, McCarthyism occurred during what is known as the golden age of American higher education, when it was expanding enormously and politicians and foundations and everybody was just throwing money at us. Today, after decades of trashing the nation's institutions of higher learning and the subsequent defunding of public colleges and universities, the academic community has been hollowed out. Many view higher education today, along, unfortunately, with much of our democratic practices, as on the brink of extinction. From the faculty's perspective, academia's most serious problem is that 75% of all instruction is now in the hands of contingent faculty members, poorly paid academics with part-time and temporary positions who lack the job security of tenure and so have no academic freedom at all unless they are protected by a very strong union contract. Now, whether or not today's institutions of higher education have the will to defend themselves, as they did not have during the McCarthy period, they may no longer have the ability to do that. Moreover, unlike under McCarthyism, which only focused on the past and present political activities of individual faculty members, the current onslaught against the university reaches into just about every aspect of higher education, except perhaps football. And even here, it's in question because the NAACP has launched a campaign to encourage African-American football players to boycott the teams at institutions where there are these educational gag rules. So we really face a very frightening future, but I can add, I think there is one bright spot. Unlike the era of McCarthyism, when faculty and students were passive and administrators sort of enforced repressive measures, there is a change. At least faculty and students are beginning to take collective action to resist the current wave of repression. Let us hope they are not too late. Thank you.
Thank you, Dr. Schrecker. Really fascinating and lessons from which we certainly can learn.